Yes, madam.
Seat number
Yes.
10, my lord.
Serial
Appellant
number?
counsel is out of station for the relative matter.
Take a mic. Take a mic.
Appellant counsel for serial number 10, out of station for his relative marriage, my lord. Kindly be called next week.
First July.
Next week, my lord.
Yes,
Please.
madam.
Please.
Yes, madam. Yes. Yes, one by one. Yes. You want to mention?
On 14th of June, my lord started a suo motu proceedings for the electrocution of elephants, my lord. My lord, due to the elephant deaths, my lordship started a suo motu proceeding. We have a similar petition relating to the railway lines between Vasco and Horsemat and Londa and Miraj, my lord. A lot of animals are dying in the Dandeli sanctuary, my lord. Kindly tag the matter along with
It must be some little different. This is, will on that day you may request.
my lord. Kindly it may be tagged, my lord.
On that day you may request. When it is coming up?
My lord, no date has been fixed. It's a 2021 matter, my lord.
All right, fix it on. Get it on second. Fifth, नहीं, कब रखा है? Second. 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 Find it. Second. Hold it.
Grateful, my lord.
2nd July.
Ammo.
Please to accord July 1st, my lord, as the date. And for the respondent number 2, my lord. Kindly
Seal
July
number
1st,
10.
my lord, that's an inconvenience. My lord. Kindly, any earlier date
Earlier date is on.
after 7th, my lord. Please.
After 7th.
Please.
So don't hold your hand, not necessary. Holding your hand is not necessary.
Grateful, my lord. Grateful.
Only before the God. Yes. So you want further beyond a date beyond?
Please. my lord.
After
7th,
first he wants date.
After
It may
7th
kindly be
July.
fixed, my lord.
this 1 to
9th
7th,
July.
I'm not in town.
9th July.
Grateful.
Please.
Grateful.
And status quo order may kindly be. Earlier status quo order may kindly be continued.
Earlier,
Status quo order may kindly be continued.
if it is there, it will continue.
Please, my lord. Please.
For the first time.
So therefore we said if it is,
No.
No.
You have mistaken.
Aviator is represented already.
no, any order is operating, just find out.
Please,
right?
my lord.
There is an order.
All the status quo order of status quo operating in the matter shall continue to operate till the next day.
My lord, may I move a writ appeal, my lord, a fresh matter where writ petition was compassionate appointment was rejected on the grounds she is a married woman, my lord. It's a fresh matter, but there are no office objections, but it's not come up, my lord.
It will
Any
come up.
date.
It will come up. No memo. Yes.
It's a recovery proceeding, perhaps. The respondent is seriously ill and the matter is to be. The respondent is seriously ill, my lord, and this matter will be taken up and kindly disposed of, my lord.
What is the
It's a
subject
recovery,
matter?
recovery proceeding, my lord. RFA, my lord.
What is? Not getting anything. Little louder, and what is the subject matter?
It's a recovery proceeding, but the suit was decreed in the lower court.
So what is the urgency then?
Just because he is a senior citizen and he is aged man.
There is no urgency. It will list it within 1 week.
My lords, one memo, my lords. In the writ appeal, my lords, I appear for the respond. By virtue of the interim order of stay, my lords, my name, my lords, in the revenue entries, my lords, have been stalled. It has not been entered, my lords. By virtue of, my lords,
Not by memo.
lords, I filed an application for vacating stay, my lords. Memo for posting, my lords.
It will list it.
Please,
Not by
Here-
memo. yes.
please.
My lord, serial number 71.28, my lords. There is an office objection. I will defect the cure, my lords. Kindly have it next
No
week.
mentioning for office. All matters will be granted 3 weeks time for removal of office objections.
My lord, serial number 76, I appear for the petitioners, my lords. The date was actually granted as 6 June. However, on that day, the matter had not come up and it's come up today, but my senior is traveling. Would it be possible to list the matter on 9th July, my lords?
9 July.
seal number 76.
9 June.
Meet, please, my lords.
Grateful.
My lords, it's a fresh matter, my lords. My lords, it's a fresh matter where the Pollution Control Board has issued directions for closure of the unit. We had filed a writ petition on 27th of May. And the matter is, all the office objections have been complied with. It's not yet been listed, my lord. So if some date may be given, my
The
lord.
number, will see why it is not getting listed. Get the number and give it to the recess. Memo, give letters, just give the number.
14-0. Okay. Grateful,
Lord.
my lords.
Yes.
My lord, requesting for posting, I'm contesting as party in person in a contempt case. I'd requested, I'd given a memo on the 30th of May, and the court was kind to grant enough 2 weeks time, but it's not still yet to be posted, requesting for.
Time is granted and to be listed. No fresh memo necessary.
Much obliged.
To be mentioned matter. Virupaksha PH.
Lords, I appear for the complaint in this case. My lord, this matter was tagged along with writ appeal, my lords. Lordship on 13th of, on Thursday, my lords, had heard, my lords, a writ appeal pertaining, my lords, to the challenge to the circular, my lord.
It's been reserved on
Please,
13th.
The order in the writ appeal was different than the order.
Please,
Yes, may I make my submission? Madam? It's the same notification under 12B1, they're making a challenge. And they're seeking for their promotions to the post based on that particular order of that single judge. And they had made the representation on that basis order, which was not considered. They had moved the fresh writ petition court seeking to consider their representation. The honorable
So
court.
this will depend upon the outcome of the writ.
No, my lord, it's the same. It's the same notification. They're coming under the same cadre.
So this
Well,
can be disposed.
Yes, my lord.
My lords, one submission. It is not on the basis of the same notification. If your lordship kindly peruse my representation, my lord. My lord, I had,
Collect that writ appeal now. It is decided,
Yes, my lord. It's been reserved
is-
for.
reserved for.
my lords, it is not on the same, my lords, subject matter. My lords, in this writ petition, my lords, we had sought, my lords, for consideration of our represent. If your lordship kindly peruse my representation at page 14, the learned single judge, my lords, has directed, my lords, to consider my representation. My representation, if your lordship kindly peruse, my lord, at page 14.
Yes, this will have to wait till it is pronounced.
My lord.
In any case, this will have to
Please.
wait.
My
Even
lords
if
may
you
post it after, my lords, the judgment outcome.
In fact, may I make a
list
submission?
it
my
on
lord?
9th of July.
Please, my lord.
May I make a submission? His representation is already answered and an endorsement is issued.
My lords,
For
they-
that, he has to question the endorsement. If your
Lords,
lordship is pleased to see, the endorsement is at ink page number 36, the typed copy is at ink page number 37, my lord.
They say, my lords, in view of pendency of the writ petition, my lords, my representation cannot be considered.
Page,
Page
Page 36.
36 is the
37, my lords, is the endorsement.
vernacular language endorsement, 37 is the typed copy of the same. He himself has made it as a
My lords, I have
annexure.
produced this endorsement, my lord. They say in the endorsement, my lords, that the writ petition is pending consideration in respect to challenge, my lords, to clause 12B. Now that writ petition, my lords, is already disposed of. It is in my favor. The writ petition order, my lords, is in my favor also.
writ petition.
Writ petition disposed of, writ appeal were before your lordship, writ appeal is reserved.
Lords, that is not the writ appeal pending, my lords. The writ petition which they refer, my lords, in the endorsement.
Now, was there a writ appeal against writ petition number
No, my
24?
lords.
1 second,
I'm sorry.
24856.
No, my lord.
So then writ appeal is against which order?
Writ appeal is based on 20991,
Ah,
wherein your lordship has reserved it under the,
It is.
yes,
same.
ma'am. If your lordship endorsement, if
The
I'm
decision
able
in
to
writ
convey.
appeal will apply to this subject.
Yes,
matter.
ma'am. Yes, ma'am.
That is it.
My lords, the endorsement which they refer, my lords, the writ petition which they refer in the endorsement.
We know that, but subject matter is same,
My
Mr.
lords, may I request your lordship to have this matter on 9th, subject to outcome of that writ appeal, my lords. My lords, because,
Complied with.
my lords, in the endorsement, if your lordship peruses, my lord, page 37, my lord.
The
They
only
say-
direction in the judgment and in the order of law and single judge was to direct the respondents to decide the representation dated 17/10/22 made by the petitioner. When the present contempt petition comes up for consideration, it was pointed out by law and advocate Mr. So and so for the respondent that endorsement come order dated 8/5/23 is passed and the representation is decided. In the said order oblique endorsement, duplicate annexary page 37, bracket over, it is inter alia stated that the representation cannot be decided for the reasons stated therein. Full stop. Not only that, it was further pointed out by learned advocate to the respondent that writ appeal number so and so arising out of writ petition number 20991
Yes, ma'am.
of
2022,
23,
my lord.
2022 was heard finally and the judgment is reserved. And further that the subject matter of the said writ appeal is same and the decision which may be pronounced therein would apply to the present petitioner.
Yes,
Full
ma'am.
stop. For all the first reasons, it could not be said that any of the respondents have at present committed any contempt, much less willful contempt of the court. Full stop. The present proceedings are not required to be continued. It is accordingly disposed of.
My lord, sir, may I request, my lord, sir, liberty in case, my lord, if, my lord,
It's always there.
my lord, sir,
It is always there.
to challenge this endorsement, my lord, because, my lord, this order may come in my opinion to challenge.
At this stage, request is coming forth from the complainant through his learned advocate, Mr. So and so, that the order of endorsement dated so and so. Is not in accordance. No, and the complainant is desirous to challenge the same, such liberty is reserved for the complainant, however, without expressing any opinion on merits.
Great.
Number 2, so contempt matters, Mr. Bhargav N.
I appear for complaint, my lords. I pray for short time, my lords.
Hmm?
Any date, 26 or 27, Syrian council is appearing in this matter. 26 or 27.
4th July.
So number 3, this education matter,
Hearing
Jai
for the
Kumar Patil.
petitioner, my lord. This matter, petitioner before your lordship is a OCI card holder registered under section 7A of the Citizenship Act. Now, insofar as the rights of these OCI card holders, my lord, the government of India has issued a notification saying that they are not eligible for government seats at all, and that they should be treated as foreign citizens or foreign nationals. That was the subject matter of the writ petition before the Honorable Supreme Court of India. And the Supreme Court of India, my lord, has held that they are entitled to all rights as Indian citizens if they were born before the date of the notification. That is, date of the notification is 4/3/2021. Now, may I just make one submission, my lord? As far as the right to participate in the counseling for government seats is considered,
It is covered by which judgment?
it is by the Apex Court judgment, my lord, which I have produced at page,
84.
please, my lord, annexure N at page 93, annexure N. This is the final judgment.
84.
The judgment starts, but the relevant portion, my lord, from paragraph 54 onwards is at page 164. Paragraph 54 at page 164. Only 4 paragraphs may be relevant as far as we are concerned.
So you are challenging some rule.
Now, what they have done is, my lord, they have said that the eligibility of these OCI card holders shall be as per the directions of the government. They are not following the judgment of the Apex Court. One. Secondly, kindly turn to page 37. Page 37. Page 37. Annexure B, page 37. After clause 6, my lord, below, eligibility, page 37. Eligibility after clause 6, as per rule 5(1) of the Karnataka selection of candidates for admission to government seats in professional educational institutions rules 2006, no candidate shall be eligible for admission to government seats unless he is a citizen of India and satisfies any one of the eligibility conditions specified therein. I am not a citizen of India. The candidates who do not satisfy any of the clauses eligibility criteria are not eligible for admission to professional courses under government quota seats through KEA. Eligibility for OCI PAO candidates for government seats shall be as per the directions of the government. This cannot be one.
So far as
rule 5.1 is concerned, my lord, the state, neither the KA or the state are insisting upon it. It has to be amended, but we are not insisting upon it.
They have to be treated in the same class.
They're actually treated on par with the
They
citizens.
can't be
then-
subjected to any other direction from the government. Because they belong to the homogeneous class along with the citizens of India.
Please, that we are not
That is the
insisting.
judgment Supreme Court. That is the
As per the
Supreme Court.
judgment of the Supreme Court, Tamil Nadu has amended, Andhra Pradesh has amended, Kerala has amended. Division bench has already granted an interim order. But in this case, my lord,
So this notification will apply to you also,
my lords, it applies to us only.
to you also.
Yes, yes. Very much it applies to us. Even the brochure also says
My
identical
submission,
terms.
insofar as 5.1, rule 5.1 is concerned, my lord, the state is not insisting upon the OCI requirement. They're treated on par with the.
State. You are
Please.
for state,
Please, ma'am.
you are additional advocate general.
I'm sorry, ma'am.
You are additional advocate general,
Yes. Additional government advocate.
you are government. It is covered.
Lord, I appear for the AEM in these matters. Lord, the question for your lordship's consideration in this particular case would be, Lord, we have treated them on par with Indian citizens. There's no dispute about it. We have given them examination also. The question now is they are claiming reservations, constitutional reservations. Whether that could be given to a foreigner citizen, Lord, is the issue which your lordships have to consider. Now, 371J, my lord,
They are
is a
claiming
special
what?
category.
They are claiming what?
371J reservation, Kalyan Karnataka reservation.
Special reservation.
Because that they are not entitled to.
It
They
is
are
not a
entitled-
reservation at all. It is
General
not a
category.
reservation at all. It is a regional
be understood by-
representation for those or whose parents have studied in the Kalyan Karnataka region.
In fact,
Now, they have denied it to me. Kindly see my application.
in fact, similar
If they had-
matter, my lord, they've
if they had-
withdrawn that.
Kindly
prayer
turn to
themselves.
page.
They've withdrawn the prayer themselves.
Pardon?
In similar matters, my lord, such a prayer was made in an earlier occasion. They've withdrawn that prayer.
No,
They have
no,
limited
this is
only
incorrect
to,
submission. No.
Okay.
No. That, my lord, was a writ petition where we had claimed.
File your counter.
Please.
Hello.
Or before. Third.
May just make one, I'll just point out one aspect, my lord. May I request your lordship to kindly turn to annexure Q, which is the interim order as far as this honorable division bench of this honorable court has already granted at page 169.
They are saying that you are asking little more than what is.
Yes, what has been.
True, that's why, and that has
Exactly.
been denied to me. Kindly turn to annexure page 74. What they are doing now. As far as I am concerned, annexure K at page 74.
So they are treating within the same class, but you are.
No, they are treating me as foreign national.
No, they are now saying that you will be treated at par with the
That means my,
citizens, with the
Yeah.
Indian citizens. But you then, you want further, further.
no,
window.
there, when I am treated as an Indian citizen, my lord, whatever is available to an Indian citizen should also be granted to me.
Treated alike. with
My
all
lords.
oth- Will be treated alike with all others.
Yes, it will be treated, but here they are denying it to me. That is the why I am before this all, that particular thing. I am only claiming the general seat, not the reserved seat at all.
What is that particular thing?
Here, kindly see page 74.
74.
74. How they are treating me. Candidate nationality, that is the fifth column from the top. Candidate nationality, they are treating me as foreign national. At page 74. Annexure K. Page 74. They have treated me as foreign national OCI.
So what is the effect of it?
Effect of this is next page, page 75. Page 75. The second column, Kalyana Karnataka 371J. This is a regional representation, not a reservation. Yes, I have claimed it. But what do they treat me? Quota claimed. They treat me non-Karnataka clause Z, which is for foreign nationals.
Oka 371J, where is that?
Yes, that, my lord. Your lordship may kindly, I'll pass on the
Name
order,
it.
presidential order
Second,
of the
second,
Karnataka.
On page 75, where is that?
second column.
Second column.
Second.
Kalyana Karnataka 371J. Very second column.
75.
But yes, page 75. First is Jammu and Kashmir migrants. No. Second one, Kalyana Karnataka 371J.
Yes.
Yes, I have claimed it. I have claimed it. Yes, I have said, yes, I want it. But what do they reply? Quota claimed. Below that, NRI, what I am not claiming.
Indian citizens are treated for 370.
Yes, yes.
Only Indian citizens.
Ah,
Only citizens.
What is that basis then?
It's a reservation, but we'll file a contempt.
They merge with the class then.
No,
They are treated
they
as
should be treated on par. These central government notifications, they should be treated on par
with.
as Indian citizens.
So then parity, they merge.
Then they'll claim SC reservation, ST reservation, constitutional reservation, that cannot be given for these students.
I am not claiming that.
They're not citizens of India. This is a question, my lord, your lordships have to, or else, my lord, they have to
So
go
let
and
us see what is
seek
the
clarification from the
what
Supreme
is
Court.
the judgment of the Supreme Court? Let us.
Please,
Supreme
please,
Court
my lord.
did not say.
Paragraph
No,
54
First time it
onward.
is coming up. Well, first time it's coming, I'll take notice on that. First time it is coming up.
We'll
I'll not-
give notice, but unless we understand, we will make again.
Yes, but I don't have the papers with me.
I'll pass on now itself.
I'm taking a lot.
Yeah. Ramesh.
Wasting time today so that on the next day there is no time needed. Straight with it.
Yes.
Annexure N.
And where is the
Supreme Court.
notification?
My lords.
There is Supreme Court judgment.
Yes.
Pursuant to, there is some notification.
Yes.
Where is that notification?
The Karnataka government has not issued any notification. On the contrary, annexure B, they say we are not eligible and it is subject to directions of the government.
You are claiming parity on the basis of the Supreme Court judgment?
Not only Supreme Court judge, yes, Supreme Court judgment plus also division bench order of this honorable court, which I have produced at annexure
Let
Q.
us see both, language of both, let us.
Please, please, first let us see the division bench judgment, if my lords permit, annexure Q.
First, we'll always go to Supreme Court.
Please, my lords, very well, my lords. At page, paragraph 54 onwards.
54 on.
Yes, at page,
Read the relevant part.
relevant portion only. Page 164, my lord,
154.
164.
Yes. One six four.
164 at page, paragraph 54. We note, my lord gets it. We note that it is not retrospective in as much as it does not affect the OCI card holders who have participated in the selection process, have secured a seat and are either undergoing or completed the MBBS course or such other professional course. However, it will act as retroactive action to deny the right to persons who had such right, which is not sustainable to that extent. The goalpost is shifted when the game is about to be over. Hence, we are of the view that the retroactive operation resulting in retrospective consequences should be set aside and such adverse consequences is to be avoided. Therefore, in the factual background of the issue involved, to sum it up, it will have to be held that though the impugned notification dated 4/3/2021 is based on a policy and in the exercise of the statutory power of a sovereign state, the provisions as contained therein shall apply prospectively only to persons who are born in a foreign country subsequent to 4/3/2021.
So you are covered in this.
Yes, I was born much prior. I was born in 2006. and my OCI card has been issued in 2010-12. Therein shall apply. The central government notification does not apply to us at all. Central government notification treats us as foreign nationals.
Read it.
Please, my lords. Are born in a foreign country subsequent to 4/3/2021, that is the date of the notification, and who seek for registration as that the respondent number 1, in furtherance of the policy of the sovereign state, has the power to pass appropriate notifications as contemplated under Section 7B of the Citizenship Act 1955 to confer or alter the rights as provided for therein. However, when a conferred right is withdrawn, modified or altered, the process leading thereto should demonstrate application of mind, nexus to the object of such withdrawal or modification, and any such decision should be free of arbitrariness. In that background, the impugned notification dated 4/3/2021, though competent under Section 7B1 of the Act 1955, suffers from the vice of non-application of mind, and despite being protective, is in fact retroactive, taking away the rights which were conferred also as a matter of policy of the sovereign state. Hence, the notification being sustained prospectively, we hereby declare that the impugned portion of the notification, which provides for supersession of the notifications dated 11/4/2005, 5/1/2007, and 5/1/2009, and clause 4(2), its proviso and explanation 1 thereto, shall operate prospectively in respect of OCI holders who have secured the same subsequent to 4/3/2021. Now, it is these clauses 4(2), the proviso, and the explanation which says we shall be treated as foreign nationals. But Apex Court says it does not apply to those who were born prior to that date or who had secured the OCI card prior to that date. So they cannot treat me as a foreign national. They cannot say Indian seats are being denied to me, and NRI is what is applicable to me. All these three things, my lord, it is no longer res integra, Apex Court has held. Now, by virtue of this notification,
Constitution.
now may I request your lordships to kindly see Article 371J, which they are now trying to deny. (371J). Special provisions with respect to state of Karnataka. And the president may, by order made with respect to the state of Karnataka, provide for any special responsibility of the governor for establishment of a separate development board for Hyderabad, Karnataka region, with the provision that a report on the working of the board will be placed each year before the state legislative assembly. Equitable allocation of funds for developmental expenditure over the said region.
Relevant, only relevant is.
Relevant, my lord. See, equitable opportunities and facilities for the people belonging to the said region in matters of public employment, education, and vocational training, subject to requirements of the state as a whole. An order made under subclause C of clause 1 may provide for reservation of a proportion of seats in educational and vocational training institutions in the Hyderabad, Karnataka region for students who belong to that region by birth or by domicile.
So who belong to the region?
Yes,
by
I
birth,
belong. I belong.
So you don't belong to the region.
My lords,
You are not by birth belong to region.
by birth, I am an Indian.
Kindly listen, you don't belong to region by birth. You don't belong to region any other way, nor you are the domicile of the region.
I am domiciled.
So
My father, the reservation order says, kindly see the local area definition. May I pass on, my lord, this?
you can't be domicile, you are overseas citizen. How can be a domicile?
No, I have come back. My father has also come back. I have studied there. That is why I am claiming.
Domicile is a concept in present.
Yes.
Huh.
Yes, I am a domicile.
Today you are not, your.
No, today also I am a domicile. For the past 10 years, I am a domicile here.
They are saying that you are class by itself as far as the applicability of 371J is concerned.
Please, that's why, my lord, your lordship, may I just pass on, my lord? The Hyderabad, Karnataka, regulation of admissions in the Hyderabad, Karnataka region, presidential order. I am domicile. I have studied there. My father has studied there.
So this is a reservation.
In a way,
What percentage?
70% in that area, 8% all over the state
8% all over the state as far as services are concerned, even for that. same is
for
applicable.
education. Also.
8%.
Education also.
8% under 371J.
Yes.
So you are
No. 70% in that particular area, 70.
you are not entitled to prima facie, take away their slice.
Kindly see, that's why, my lord, prima facie, according to me, clause 4 of that.
Difficult to accept your content.
Please,
Although
please,
we
my
are
lord.
issuing notice.
Please, no, may I just read one clause, my lord? Permit me to read one clause.
What you are reading?
Yes, domicile. Definition of domicile,
That is.
please. Definition of domicile. If I fit into this category, I am entitled to.
That's right.
There is no way it can be denied to me.
Where is that page?
Page, my lord, on the second page, my lord,
Domicile.
domicile, clause, provision 4. Domicile.
Local person says defined in paragraph 4.
Yes.
Go to 4.
Yes. A candidate for admission to any course of study shall be regarded as a local person in relation to the local area. Now kindly turn to, my lord, clause B. In cases where minimum educational qualification has been prescribed for admission. In this case, I am seeking admission to medical, my lord, minimum educational. Kindly see clause 3 there, next page. Clause 3. In my case also it will apply, but clause 3 is more specific because it requires 10 years of study. Clause C, where either of his parents has studied in an educational institution in such local area for a period of 10 consecutive years. My father has studied. I have not studied for 10 consecutive years. Yes, because I was born in India. My father went to UK. He took up citizenship there. I became a citizen because my father also became a citizen. But my father came back and he settled down again in Ballari. Now, he studied for 15 years, consecutive 15 years, till he completed his second PUC. Thereafter, including his medical education, he has done in Ballari. So, yes.
You are producing some acceptable evidence?
My lords, yes.
What
Yes,
you are-
kindly see. I have produced here also, as well as kindly see the study certificate, annexure E1 of my study certificate, annexure H1 are my father's certificate for 10 consecutive academic years. And annexure E, page 65. I am producing, I have produced it.
55.
5. 65.
65 is the
Study certificate.
Study certificate.
Yes.
Of student.
Of the student.
You are saying that your parents were domicile.
Yeah, even that also I have produced in addition to that. Yes, that is at annexure F1 H. Kindly see H at page 69. This is of course in Kannada, my lord. My Lord Justice Arvind may be in a position to appreciate. Vyasanga Pramana Patra, study certificate. This is from 1st standard to 5th standard, one certificate. My father, that is my father's name is Kuruvalli Renuka Reddy.
79 to 84 only.
Yes, 17. Then second one, 84 to 85.
84 to 85.
Yes. Then third one, 85 to 88. That is 7th standard to 10th standard. Then 88 to 90, first year PUC and second year PUC. So starting from 79 to 1990. And the eligibility certificate issued by the department, revenue department. That is why I have claimed Hyderabad, Karnataka, Kalyan, Karnataka.
Local person to procedural. What is the
in cases where no, so the paragraph 4 regarding domicile.
Please, my lords.
Cases where no minimum educational qualifications. are
Yes.
prescribed. What
In
does it-
cases where a minimum educational qualification has been prescribed,
What does it signify?
it means, my lord, for example, for any,
This concept will apply in respect of courses where probably, where no minimum educational qualification is prescribed.
yes. This will apply where minimum educational qualification has been prescribed for educational institutions. I am seeking admission to MBBS course.
So this C will apply in cases where no minimum educational qualification. Any decision of this kind on this?
Milord,
No.
Milord, there, no, Milord, on this issue, there is no. Because earlier, Milord, the series of litigations were there from OCA card holders. And Milord, in all those cases, nobody has, they specifically said we are not claiming reservation. And that was, Milord, ultimately, Milord, the central government changed this notification itself. In the notification, they have given a, Milord, restricted this thing to appear for a NEET or any.
No, in any case, whether.
This
you are
is
a
unique to Karnataka because, my lord,
You are a domicile or not.
I am a domicile, very much a domicile. I
Correct,
kindly see page annexure G, page 68, domicile certificate issued by the Revenue Department.
Kindly listen, that question would depend upon each case.
Please,
You can't generalize that we are.
No, I am a domicile. I am a domicile. I am a domicile. As on today, I am a domicile. I have studied and my parents were domiciled for 10 consecutive years.
You have taken this contention in, this contention in the petition.
Yes, yes, this is precisely my contention.
You are a domicile.
Yes, yes, that
Or
is my
learned
ground.
advocate, Mr.
Kindly
so
see.
and so, so and so for the petitioner and learned advocate, learned government advocate, Mr. What is your good name?
Sudev.
Sudhir?
Sudev.
Sudev. Sudev and learned advocate, Mr. So and so, for
Ramesh, NK Ramesh.
N.K. Ramesh, for
For Karnataka
Second
exam-
respondent, third respondent, Karnataka Examinations Authority.
Karnataka Examination Board.
The second respondent, I'm sorry.
For learned advocate, so and so, then both advocates, so and so, will accept the notice, then accept the notice. Respondents shall file their statement of the objection. So when this, then the deadline of admission.
May I just, calendar of events. 30th, my lord, the central government will be announcing the NEET results for those candidates who have gone to the apex court. Now, the calendar of events was issued just last week, my lord. 30th is the date on which. Thereafter, my lord, on the 6th of July, the All India counselling is likely to start as per the calendar of events already published. The state government, KEA, is likely to conduct these counselling for medical and engineering maybe after the 6th of July.
Fresh need.
My lords,
After 6th of July, it's only after. Milord.
after 6th of May. Likelihood, because central government notification, All India counselling has to first happen. After that, only the state government will conduct the
6th of
counselling.
July, May is over.
No, 6th July, I said, July, I'm sorry, 6th July. 6th July is when the central government or the medical counselling committee of DGHS is likely to commence the counselling. 6th July.
Keep it on 5th July.
Please, my lords, please, my lords. For consideration of interim prayer.
Yes, we will file our objection.
It appears to be an interesting point.
Yes, it will be
He's
fine.
also trying to develop very well.
Yes.
Subject to, you have to answer.
Because this is unique to Karnataka, my lord, Hyderabad, Karnataka. That is why it is arising. And if I may just point out one other aspect. In Hyderabad, Karnataka, seats are there for general candidates.
But any notification or whatever is not.
No, seat matrix has not been issued.
Not issued by the
Nothing-
state.
Nothing has
That
been
is
done.
likely to happen after the 5th of July.
Giving effect to the Supreme Court judgment.
No, that is our grievance also in the writ petition. State government has not issued any notification giving effect to the apex court judgment. I'll point out, I have produced the Tamil Nadu notification. Specifically, it amends and says they are entitled for all general seats.
That's the reason you now notification.
So you are
is sent.
deliberately keeping some windows open.
Reason I said not.
By not issuing notice.
In my notification, we have said we are awaiting this. We have written
No,
to
but
them.
you have to take a stand.
Yeah, they have to take, no problem. They have to take a stand. Your Lordship,
Is
sir.
the concept of domicile in this act is in the nature of deeming fiction.
Yes,
And you are aware that deeming fiction has to be taken to its logical end.
yes. But another question bugging is, Lord, they cannot have any other right what has been given under the notification issued by the central government.
Which is not, which is that?
7B.
Is not applicable to us. Apex court just read out, my lord. It's not applicable at all to us.
No, no, which is that?
That notification, my lord,
I have produced.
was questioned, my lord, in this very
Supreme
SLP. Notification was not quashed.
Page 79.
Notification was what?
Where is that notice?
Page 79.
79.
Relevant portion is at page 81.
Page 38.
79, 79. Relevant portion is at 81. The English portion is at page 81. From 4 onwards. What matters, my lord, is from clause 4 onwards. Parity, may I read, my lord? Parity with non-resident Indians in the matter of inter-country adoption of Indian children subject to the compliance of the procedure as laid down by the competent authority for such adoption. Appearing, next page.
This one.
This is the relevant portion. Appearing for the All India entrance test,
Next one.
such as national
Two.
eligibility come entrance test, joint entrance examination means joint entrance examination advance, or such other tests to make them eligible for admission only against any non-resident Indian seat or any supernumerary seat, provided that the OCI card holder shall not be eligible for admission against any seat reserved exclusively for Indian citizens.
So this will not apply to you?
It will not apply. It
Why?
will not.
Why?
Supreme Court says, that is the judgment, paragraph 54, which I just read out. Supreme Court says, this notification dated for specifically 4/3/2021 and the proviso shall not apply to those who were born before that date or who had registered themselves as OCI card holders before
your
that
lordship
date.
kindly see
It
the
does not apply at all.
Explanation.
Very
down below.
clear, specifically.
In 82
Proviso is clearly mentioned in paragraph
Explanation.
57, 58.
In 82.
Then explanation, even this, may I just point out explanation, my lord?
Lot number of overseas citizen contest,
Yes.
lot number.
Yes.
Yes, yes,
They have
yes,
taken
yes,
a
yes,
chunk
yes.
of, my lord, the seats of reserved for Indian citizens.
Yes,
Not we
in
are,
the sense there are about 100 candidates, ma'am, in Karnataka.
Oh, we are giving them under the general merit quota.
This
There is no issues.
notification will not apply because Supreme Court says no.
Supreme Court says no.
Supreme Court is interpreted.
My end of it.
Supreme-
Supreme Court doesn't say give them reservation.
No, that will arise only here. In this case, it is arising
Go
for
ahead,
the
ask.
first.
Seek for it.
Supreme Court has not given you the reason.
Reserve, no.
The Supreme
No.
Court has said to be treated on par with Indian
Been
citizens.
considered, it is debatable.
Yes.
That is the issue. It is debatable. I do agree. Fifth July.
5th July.
5th July. By then we will know whether the counseling, when it is going to start. If an earlier date can be given, I have no objection.
No, madam,
But
we
they-
will file our objections for it.
Very well, very
They
well.
are only given 3 weeks. less
Please,
than 3 weeks.
please.
We are giving seats, my lord, under general merit category. No
No.
issues about it.
My lord is fixing for 5th July, my lord. Oblige. Ramesh.
Number 4, Mr. Vinay Kutappa.
Now, how can you be permitted to be corrected? Now you can be permitted to produce a caste certificate.
But down on the nature of the prayer which he has made, he has
Yes.
to make, my lord, the NTA a party. But changing, my lord, the NTA is, the application is filed at NTA, not the National Testing Agency.
So make a party.
You have to make a party and take notice to them.
Leave to amend the course title by permitting to add. Which party? Which party you want to add?
My lord, national testing, make them a party.
National Testing Agency. National Testing Agency, party respondent. Amendment of the course title shall be carried out. After the amendment carried out, there shall be notice to the respondents returnable. Returnable on. We serve them. 27th.
There's no, immediately, my lord, there's no, counseling goes on.
Again, this is neat.
It's a need,
It will
still
take-
in, my lord.
It will take.
Let him serve them, my lord. If they come, my lord.
So, 25th. 25th. We are saying 27th. 20.
Sir, PL matters, number 5, Mr. J.R.
Petitioner. My lord, I have filed this petition for a direction to the respondents to provide facilities in the government hospitals situated in the Taluka headquarters of Kamalanagar Taluk, Chittagoppa Taluk, and Hulasura Taluk of Bidar district. My lord, these government hospitals, they do not have even the basic facilities such as, my lord, labor ward, operation theater, facility for blood transfusion. And these are the minimum requirements, my lord, to be provided. Because of not providing these facilities, my lord, the people living in these taluka headquarters, they are constrained to go over to other taluka headquarters for even these basic facilities.
To the nearest hospital. What's the nearest hospital?
Nearest means, my lord, the people have to go a minimum of 50 to 70 kilometers they have to travel. Even
Is it so?
a woman having a labor pain,
You don't see of having primary health center at each taluka level.
Lord, they have, my lord, but I'll have to verify because they are newly created taluks.
Here there is, wherever you are a primary health center, there are no doctors. But here there is no primary health center.
Lord, I'll take notice for respondents one.
Heard learned advocate. At least you provide the timeline within which you will set up and we'll dispose it of, correct?
much.
Heard learned advocate, so and so, so and so. The grievance raised in this public interest petition is that at the new taluka places named
Kamalanagar Taluk, Chittagoppa Taluk, and Hulasura Taluk of Bidar district.
it's in this public interest petition. The grievance of the petitioner is that in the year 2017, three new taluka headquarters in the district of Bidar came to be formed. They are Kamal Nagar Taluka, Hula Sura Taluka, and
Chittagoppa Taluk.
Guppa Taluka. They are the talukas under the Kalyana, Karnataka region. Full stop. Despite formation of the new taluka, or at such taluka places, no government hospitals or even primary health center. Even primary health center is not.
My lord, that may not be.
Primary
correct,
health
my
center
lord.
is there, my lord, but they
Looking for upgradation of the hospitals. I'll take notice, my lord, and I'll get back to my lord if my lord grants me some time. How many primary health?
There are
It
hospitals.
is the case that in these talukas, the government hospitals have not been upgraded.
Yes, my lord.
Full stop. Notice to the respondents written ever on.
Lord, notice will have to go to respondent number 4. I take for respondents 1, 2, 3.
Notice to number 4.
Yes.
Learned additional government advocate. So on so to accept notice on behalf of respondent 1, 2, 3. So returnable date will be 19th of July.
Obliged.
19th of July.
Much ob-
You file an appropriate reply and we'll dispose it. Yes.
Writ appeal matters, Cecil number 6, Mr. Shivaswamy.
My lord, I appear for the appearance from sale.
That
It's
25
SC
years
estimate, my lord.
delay of.
There is a delay of 194 days in wait.
Group is today. Today there is a group along with it.
It can be connected with that matter.
Number 7. Number 7, Mr. Rajesh Kumar.
Yes, sir.
Bill, my lord, filed by the university. There is a delay of 113 days, my lord, in one case. There are 2 appeals, my lord.
Pension, you are not paying pension.
Lord, pension, my lord, it was paid, but 25 lakhs, my lord, which he has drawn, for that, my lord, he had not submitted the accounts, my lord. He has not submitted the bills, my lord, for having utilized that amount. For that purpose, my lord, only 25 lakhs, my lord, was withheld. Then, my lord, proceedings was initiated, disciplinary proceedings. And at that time, my lord, they approached the Dishonorable Court and obtained an interim order on the ground that the proceedings are initiated after 4 years of the date of the transaction or what incident, my lord. Because KCSR says that after retirement, my lord, within 4 years, my lord, an employer can initiate proceedings for any of the misappropriation or whatever that is, disciplinary proceedings against an employee. On that ground, that, my lord, the reason why, my lord, it was initiated late was because he was a professor there in the university. Lord, we have given him a sufficient time. He was asking time, he was given a sufficient time. We did not want to initiate action, my lord, against him. Then, my lord, it was initiated finally. Then at that stage, my lord, it's a common order in 2 writ petitions. Common order. That is the reason, my lord. Lord, my submission is, Lord, the learned single judge has passed an order, my lord, to pay the amount. But the interest part, my lord, at least that part, my lord, could kindly be considered.
Well, if I may,
Single judge passed an order, my lord, to pay the interest, administrative rate of interest also. Plus, if that part, my lord, if it's
Lords, if I
reduced, my lord, then, my lord, I may not have any objections, my lord, so that, to that extent. Because it is an admitted fact that, my lord, he has not submitted a bill, my lord, for
my lord, if I
25
may.
lakhs which he has drawn.
The amount is paid.
My lords, I have not drawn, my lords. That may not be right, my lords. What happens is a scheme is introduced for digitalization of panchayat. Subsequently, my lords, the appellant university enters into an agreement with an outsourcing department. And my lords, as per the MOU, my lords, certain funds were to be released, and subsequent to entering into MOU, I was appointed. My lords, what happens is in the midst of the process and the funds were being released, without any reason, government withdraws the scheme. My lords may kindly see his reply at page 105. My lords may have a picture. My lords, I am holding the writ appeal 469, my lords. Wherein, my lords, and in,
My lord, you are aggrieved against the interest part only.
Yes,
my lords,
that is the.
What is the rate of interest, admissible rate of?
8% as per their government order, my lords. 8%.
Government order.
There is a government order, my lords. Today I am unable to fetch it, but 8% is.
The rest of the dues you are paid.
My lords, the thing is, my lords, my lords, pardon me, my lords, I didn't get my
Paid
lords'
the-
question.
You have paid the principal amount?
My lords, I am not entitled to pay the principal amount, my lords, because I have not taken it. That is what my contention is. And moreover, my lords, this cannot be urged for the reason that, my lords,
No, my lord, this.
lords, 25 lakhs they have withheld, my lords.
Other
That I
time-
am claiming with interest for the reason, my lords, I myself have
Why
issued.
they have withheld 25 lakhs?
My lords, saying that I have withdrawn, I have taken the 25 lakhs amount which I have to reimburse. That itself was wrong is what held by learned single judge, which they are accepting. Their only claim is with respect to interest part, my lords. My lords, I myself,
Before us, the university is aggrieved only because of the interest granted.
true, my lords. That is what they are submitting.
So rest of them, they are the appellant.
True, my lords, true, my lords.
So we say, what is the?
For interest, my lords, my submission is that I myself have appraised them about the fact in the year 2016. My lords, then in the year 2018, when, my lords, it is at 64, I have issued a legal notice. My lords, then in the year 2018, when I filed a writ petition on 1st of March 2018 seeking retirement benefits, after notice being served upon them, they come with an articles of charge. Till then, they don't take any action, my lords. They purposefully evade it. And my lord, such being the circumstance, they cannot deny interest on me, my lords. And then I myself have been present before them. I have filed repeated representations and I have also issued legal notice. Pardon me, my lords. I have also issued legal notice to them on 20th April 2016. My lords, I was retired on 28th February 2015. Since then, they have not paid me. And it is not the case where I am running. It is the case where they are denying. And I have filed repeated representation also. And when writ petition is filed on 1st of March 2018, my lords, then in the month of October, they come with the article of charges, which is again against the KCSR provisions of 214(2)(b)(2).
My lord, the university is not aggrieved even with the levy of interest, my lord. There are no legal contentions if my lord were to take the grounds in the first writ appeal, 469 of 2023. They are not aggrieved even against the interest part.
Round number 10 may kindly be seen. I said the interest also.
My respectful submission would be, my lords, when I myself have presented before them on numerous occasions and they delayed continuously. And after I filed writ petitions, that too after 7 months of I filing writ petition, when notice is served upon them, they now say that interest cannot be given is where no fault of mine is concerned. I have retired in the year 2015. Since then, I am approaching them. And his submission that I have taken 25 lakhs is not correct, as learned single judge has also recorded the same. If they are accepting is what now he is saying it.
So initially, the benefits were not released because of
The dispute.
inquiry.
Inquiry was not initiated at all, my lords. After writ petition was filed seeking retirement benefits, articles of charges are issued.
Inquiry was initiated.
My lords, articles of charges was only issued on 14/9/2018.
Inquiries were never undertaken.
No, no.
14/9/2018, my lords, after I filed writ petition.
They left it.
2018, my lord.
Lords, I approached them, I give legal notice to them, they don't initiate anything.
And that was the reason for delayed payment.
Yes.
No, no, my lord, I have said, my lord, in my statement of objections before another single judge, page 133 may kindly be seen. My objections, my lord, are clearly mentioned. How, why this?
They say I was evading it.
He has withdrawn the amount and he has not submitted accounts for having paid the amount to that Sampurna or whatever it is. He has not submitted a voucher, my lord.
So in view of rule 214,
2B2, my lords.
if it is beyond 4 years, then not permissible.
That is true, my lord. Not, but
Sorry, dismissed.
only the interest of part of it, my lord, my only intelligence, my lord, only on that.
Much obliged. Deeply
Delay, my lord,
obliged.
there is a delay in this filing.
Delay, we don't mind. It is dismissed.
Deeply obliged.
Two appeals, both are dismissed. Both are same?
Same, same. One is for retirement benefits, my lords. One is
Law. What
articles.
is your, I've done the appearance. What is your good name?
Sridhar, my lords.
Sridhar.
Sridhar Bidri.
Seal number 8. Maitri Krishna.
I appear for the appellant, my lord. The appellant is a registered trade union. We have approached this honorable court, my lord, challenging the order of the single judge, whereby the interim order in my favor was vacated, my lord.
Why should we entertain it
My lord, it's a,
against interim order?
please, my lord, it's an extremely unique case, my lord, where the interim order sought for, my lord, pursuant to the interim order, only final order can be granted, my lord. I'll just take my lordship through the facts of the case.
Let us see the order.
Please, my lord. The impugned order, my lord, is at page 42, my lord, whereby the interim order initially granted in my favor is vacated. What is sought for, my lord, is an interim prayer, is conduct of a referendum, which is agreed to by all the three unions, including the appellant herein. It starts at page 42, my lord. And at 44, my lord, the first interim order in my favor is recorded, my lord, at para 5. If I may read, my lord, at page 44. Para 5, my lord. Then the speaking portion, my lord.
So here only interim order is vacated.
Please, my lord. My lord, if I may take my lordship just 2 minutes time of my lordship to convince why this is a very specific and unique case where, my lord, some interference might be required, my lord.
Lord, paragraph 27 is
Conducting the
very clear.
referendum accepted by the charter of demand.
Please, my lord, if I might just for 2 minutes, my lord, take my lordship through why this is necessary to interfere with,
There
my
is
lord.
nothing final in this order.
No, my lord, the reason why it's necessary, my lord, is that what happens, my lord, is that the referendum is repeatedly conducted in this establishment in previous occasions. Now what happens is that I am the recognized union from 2011 after conduct of referendums on various occasions. Thereafter, what happens is a management sponsored union comes into being and I'm de-recognized on the sole ground that I have lost majority. I repeatedly say I'm ready to obey the will of the majority, conduct a referendum. I also, my lord, issue a representation to the Labor Department stating that collusive actions are taking place, and to stop these collusive actions, a referendum may be conducted. A meeting is held, my lord, whereby all three unions agree to hold the referendum, my lord. Though all three unions agree to hold the referendum, my lord, it is the management which is reluctant, which is in fact an unfair labor practice, my lord. The management should have no say in which union is a majority union and which union is a minority union. At that time, my lord, before the referendum, my lord, I give a representation saying they're going to sign a settlement with this minority union, which is a management-sponsored union. And please maintain status quo. I request the Labor Department, my lord. The sole ground for rejection, my lord, the vacation of the order, my lord.
Your main petition is pending, you can.
But my lord, the reason why it's necessary, my lord, is that once referendum is rejected, the findings of the learned single judge in the interim order, my lord, impugned, will affect the final prayer as well, my lord.
We'll clarify,
My lord,
we'll clarify that all findings are tentative.
please, my lord. My lord, in fact, my lord, a referendum might be vital in this case if my lordship might consider kindly. It might be vital. A referendum prejudices no one, my lord. A referendum is something which only
Lord.
determines who has majority.
My lord, paragraph 18 and 27 may be seen, my lord.
In fact, the Labor Department has also expressed its willingness to conduct the referendum. The sole block in my prayer, my lord, is the management. The government also has conceded that an referendum may be conducted and has suggested the same in Annexure AP. All the unions have also agreed to the same, my lord. And despite this, my lord, a settlement is signed with the majority union, with the management-sponsored union, on the basis that they have majority. When there's no document saying that I have not proved that I have majority anymore, but I've repeatedly given numerous representations stating that I will prove my majority and I will bow to the will of the majority. The sole ground, my lord, for vacating is that the settlement has been signed, my lord. But I repeatedly requested, don't get the settlement signed without hearing me or without the referendum. So I'm put in a catch-22 situation.
Heard learned advocate, so and so for the appellant and learned additional government advocate, Ms. Neelofar Akbar, for the respondent state and its authorities. Upon service of the copy of the appeal in advance. Petitioner, the appellant hearing. This is the original petition, which in the writ petition claimed inter alia that it was a recognized union and that in capacity of a recognized union, it entered into a settlement under section 2 into bracket small p of the Industrial Disputes Act 1947 with the management. It was the case further that it is the further case that the relationship between the petitioner and response for management which was otherwise harmonious, became strained. And on 9/8/21, the erstwhile General Secretary of the Petitioner Union, once the T.R. Venkatesh and the management colluded and all disputes between the parties were withdrawn without consent of the union. It was stated that later, State Sri T.R. Venkatesh formed a separate union bearing Tinmaya Mission Hospital Workers Union. With such basic premise of facts and the pleadings, the writ petition was paid to declare as illegal and impermissible the action on part of Respondent 3, Deputy Commissioner of Labor, to close the conciliation proceedings. It was further paid to set aside factual failure report dated 26/12/2022. It was the prayer to direct the respondent to reopen the conciliation proceedings and facilitate amicable settlement of the Charter of Demands over and above the Memorandum of Settlement dated 4/3/23. Full stop. In the proceedings of writ petition, learned single judge pass order dated 10/7/23 in IA number 1 of 23. It is this order dated 10/7/23 which is brought to be challenged in this appeal. The said interim order resulted into vacation of the order dated 21/4/23. Initially, it appears that the following interim relief was passed on 21/4/23, page 44 over. What was directed by the aforesaid interim order was to conduct referendum. And respondent number 1 to 3 authorities were directed to take steps for appointing the returning officer for conducting such referendum. Full stop. By the impugned order, by the order impugned in this petition, which was an order upon interim application, from the said interim leave came to be vacated. Wherever. While when learned advocate for the appellant was confronted with the aspect that the order brought under challenge is only an interim order and the proceedings of the petition, writ petition are pending. She was entirely at her receiving end and could not dispute that the parent proceedings are pending and the rights of the parties are yet to be finally determined. First of the order being interim in nature, the order being interim, the impugned order being interim, by its very kind in nature, do not crystallize rights of the parties finally at this stage. Paragraph. Only apprehension, not only, the apprehension which was expressed on behalf of the appellant was that the observations made in the impugned order will influence the final decision, may influence the final decision in the writ petition. Full stop. It is made clear that since the order itself is interim order, the observations made therein shall have tentative value and shall not influence the final decision which may be taken by the learned single judge while deciding the writ petition. Full stop. With above observation, only on the ground and without going into the merits, only on the ground that the impugned order is interim order, without going into any aspect of the merit, the present petition appeal is not entertained and disposed of. Learned single judge shall decide the writ petition strictly in accordance with law and on its own merits. Right? Starting में लिखो. The writ petition could itself be taken up for final consideration with request and consent of both the sides.
It's number 9.
Could taken up for final consideration at this stage itself.
Serial number 9, my lord, I appear for appellants, my lord, counsel. Appeal is, my lord, by the Karnataka Industrial Areas Development Board.
Yes.
Against the order of the learned single judge, my lord, directing the board to execute a sale deed without, my lord, insisting upon the letter that was issued, requiring the allotee to pay, my lord, penalty. My lord, your lordship may kindly take the synopsis.
We'll issue notice.
Yes.
Notice returnable on 18th of July.
Interim order, my lord, because contempt is also linked, my lord.
It's linked, my lords. Nothing will happen.
Contempt shall be listed on along with the.
No, it's already listed, my lord, today. It is
It's already listed.
Now again will be listed. No interim.
Please.
Sir, 10 urgent, seal number 11. Mr. Vittal BR.
For the appellant, my lord. In this particular case, we are challenging the judgment in WP 25528 of 23, my lord. The judgment that is provided in this particular case is contrary to the law and certain facts also, my lord. That's the reason that we are challenging this particular judgment. Now, if we go to the judgment, which is in page number 45, 44 and 45. I would like to read out the main aspect as far as the judgment is concerned, my lord. Especially paragraph 17. Paragraph 17 says, since the project does not involve commercial unit, the Register of Cooperative Society do not have granted permission dated 18/10/23, marked at Annexure A. Accordingly, the same is quashed. Now, in this particular case, my lord, we are a project which is registered under the Real Estate Regulation and Development Act, that is RERA in short. So provisions of RERA is applicable. However, the single judge has not considered the provisions of RERA. We have provided the certificate of RERA, the registration of RERA, but the single judge has overlooked all the provisions of RERA. And he has quashed, because as per RERA, if you go into section 11(4)(f) or 11(4)(e) rather, as per RERA, the 11(4)(e) clearly talks about formation of an association. So I would like to just read out from the Act 11(4)(e), which says, enable the formation of an association or society or cooperative society, as the case may be, of the allottees or a federation of the same under the laws applicable. So here, we had filed an application to the cooperative society to register our association as a cooperative society. The petitioners in WP challenged that particular order of the Register of Cooperative Society, where they had asked us to collect the share capital. We have done it in line with the provisions of RERA, that is 11(4)(e). Now, the single judge has not considered our prayer that we are a part of RERA and gone ahead and said that the association needs to be formed under the Karnataka Apartment Ownership Act. However, my lord, I would like to bring to your notice, there is no association that can be formed under Karnataka Apartment Ownership Act. No provision is available as far as the Apartment Ownership Act is concerned. The Apartment Ownership Act is enacted specifically to aid transfer of property, my lord. If you go into the objective of the Apartment Ownership Act, it's very, very clear. It talks about the transferability and heritability of the property. That is all. There is no other aspect involved with Karnataka Apartment Ownership Act. So Section 6D, my lord, of Transfer of Property Act does not allow the alienation of undivided interest, while apartments are purely on undivided interest, my lord, because the land share, common areas are based on undivided interest. Now, since Section 6D of the Transfer of Property Act does not allow the alienation of undivided interest, that is the reason the enactment of Karnataka Apartment Ownership Act came into existence in order to supplement the Transfer of Property Act. However, the single judge has gone ahead and decreed saying that association needs to be formed under the Karnataka Apartment Ownership Act. It is not possible to form any association under this particular act, my lord. For that, the government of Karnataka enacted Karnataka Ownership Flat Act, which is Act 16 of 1972. That also is in line with the RERA, my lord. All provisions of Karnataka Ownership Flat Act and RERA, if you compare it apple to apple, the provisions are similar, my lord. The single judge has also taken 2 judgments of Karnataka High Court, one of the division bench, one of the single bench, which was in this instant case. However, if you make an exception to apply these 2 judgments or one of these judgments, that is CRP 96, it clearly says that when the property is not subjected to the Karnataka Apartment Ownership Act, RERA applies. So here, my project is completely purely registered under RERA. Hence, only the provisions of RERA needs to be adhered to, my lord. Another contention taken by the single judge, my lord, in paragraph 18, my lord. We have an interim application, my lord. The reason for the interim application is that we had filed an application to vacate the interim stay that was given against our society. So we filed an application to vacate the stay on the 21st of January, 2024. Along with that,
You're a society at present?
We started the formation of the society, my lord, but we are not registered completely.
Then how can you describe your name as in the title as cooperative society?
We are proposed cooperative society.
It is written
Yes,
as proposed.
proposed cooperative society.
Let us.
Because the process is in between, my lord. It is ongoing. The process is ongoing.
But dismissing the appeal on the ground of wrong post item only. You are not you are not cooperative society.
No, we are a
You-
proposed.
In the capacity of cooperative society.
No, we have mentioned as proposed cooperative society.
How can it be?
My lord, that is what the
Proposed, there's no existence in eye of law. unless it
exactly,
is-
my lord. Even the WP does not exist. WP, the writ petition also is not maintainable in that circumstances when they have filed it against the proposed society. Exists, does not survive, my lord.
So what is
So
wrong in the,
they
what is,
need
what
the-
is wrong in the direction of learned single judge?
The learned single judge has not looked into the provisions of Real Estate Act, which we are registered, that is RERA. We are completely registered under the RERA, my lord. And the single judge has not even looked into those provisions. As per the provisions of RERA, we are supposed to be forming a cooperative society. But the single judge is saying that we need to form an association under Karnataka Apartment Ownership Act. There is no formation of association and registration under Karnataka Apartment Ownership Act.
So it is for the owners to decide whether to form an association or cooperative.
The owners have decided, my lord, that
Okay.
they have asked for cooperative society to be formed.
You only saying, you only saying as a petition.
No, we have provided the letter signed by the majority of the owners to form the cooperative society. Even the respondent number 16, my lord, has provided a letter to us.
My lord, may I make one submission, my lord? My lord, the writ petition and the relief, if my lord were to see, there's not even a word of RERA mentioned there. It is for the first time that in the appeal, these contentions are taken.
No, this
My lord,
section-
may please see if we take the prayer sought
Section
for
is-
in the writ petition.
Section is quoted at page 17.
My lord, writ petition was filed by the respondents here.
So is
My
it-
They
lord,
have not taken
appellants were
contention.
respondent number 4.
We have taken the contention. In the objections, we have taken the contention. We have also filed in,
Prayer may be seen, that is what the prayer sought for.
They are in simple language, they are saying that they want to form a cooperative society.
Society,
And the majority members want the cooperative.
yes. And the learned single judge has said it's not possible because it is a residential apartment.
it is incorrect, my lord. I would like to indulge your good
I
self.
can understand if those contentions, my lord, were mentioned by the learned single judge at the time of arguments. My lord, that is not contended at all.
We have contended that we are a RERA registered
There's
project.
no
in our
mention of
objection.
that, the arguments.
Even in the arguments, it has been taken,
My
even
lord,
in our
that could have
objections.
stayed, that could have been stated before the honorable single judge saying that these are my contentions. Please take note of my contentions and pass necessary orders. That is not the case of the appellants here.
So in case of residential units, there is no.
No.
No, my lord, I would like to correct this statement of learned government advocate. It's a misconception, misconstruction of the act itself, my lord. I would like your good self to indulge in Karnataka Apartment Ownership Act. I would just like to read the section 2 and certain provisions of Karnataka Apartment Ownership.
My lord, I can understand if those contentions.
No, my lord, the
were-
contentions taken is incorrect,
My
and this is
lord,
what
the
is happening, my lord.
contentions Had been noted by the learned single judge.
That is an incorrect contention noted by the single judge, my lord. My lord,
The contentions are taken, my lord, the learned single judge wouldn't have overlooked those contentions.
it is taken, my lord, it is taken. When we file the objection. 2, 3 provisions. Section 2. Section 2, my lord, application of the act. My lord, the act applies only to property, the sole owner or all the owners of which submit the same to the provisions of this act by duly executing and registering a declaration hereinafter provided. Provided there's a comma, no property shall be submitted to the provisions of this act unless there's a comma after act, unless it is mainly used. My lord, please note this sentence, unless it is mainly used or proposed to be used for residential purpose. That means it can be subsidiarily used for commercial purpose.
Where you are reading?
Section 2, my lord, of the act. Section 2 of the act, my lord. There's commas, my lord. Commas are very, very important in English. Provided that no property shall be submitted to the provisions of this act, comma, unless it is mainly used, comma, or proposed to be used for residential purpose. Mainly used meaning it need not necessarily be only residential, my lord. So the contention taken by the single judge saying that only residential projects needs to be under Karnataka Apartment Ownership Act is totally incorrect.
My lord,
Second-
please take paragraph 8 of the order of the learned single judge, my lord. The defense of the
let me-
respondents therein has been culled out. And then paragraph 12.
My lord, I would like to read another provision of this act. Definition, section 3, section 3A. Apartment means section 3A.
What are you showing?
My lord,
You're showing what?
I couldn't get you, my lord.
What you are showing to us?
My lord, I'm showing you the definition of the application of this act as far as KOA is concerned. Because the learned single judge says that only for residential purpose. But here it is also commercial.
Paragraph 8, the defense is clearly culled out by the learned single judge. My lord may see the order from paragraph 12 onwards, my lord.
My lord, I would like to just make one submission, my lord, in page number 137. One submission, my lord, page number 137. That is the objection that we have filed in the writ petition. In paragraph 4, we have clearly mentioned, it is submitted that the allegation of the petitioner that some of the flat owners were attempting to form an established cooperative society by collecting share capital from the owners of the flat. The said act to the promoter of the proposed society is contrary to the provisions of Karnataka Ownership Flat Act and sale and this thing. The contention of petitions are totally false and baseless. So we have taken even the Karnataka Ownership Flat Act as well as RERA. Now, when the project is registered under RERA, my lord, no other provisions come into play. Only provisions of RERA. So 11.4E, 11.4F, 11.4G, section 17 needs to be fulfilled for the formation. And also as far as the builder, he has given us a letter to form the cooperative society. He has given us office space to form the cooperative society, my lord. It's very clear. And we started the formation after calling for a meeting. 80% of the people agreed for the formation of a cooperative society in this particular situation. The definition of apartment in RERA as well as KOA is similar.
My lord? No, my lord, I appear for respondents 1 and 2. All the other are private response.
My lord, this is a RERA project, my lord. It is not a Karnataka Apartment Ownership Act or COFA project. So provisions of RERA has not been complied. Provisions of RERA has not been complied, my lord. Compliance to provisions of RERA is important, my lord, in this particular case. The single judge has not considered that. Because section 88 and 89 of RERA is also very important in this case, my lord. 89 clearly talks about what is the provision of RERA. Section 88 and 89 is important before dismissing this particular case, my lord.
Still number 12. Balasubramanian.
For the caveator counsel.
My lord, respondent before your lordship, my lord, borrowed money from State Bank of India, nearly about 40 crores. Thereafter, my lord, he came to us saying that, please take over the loan that I had obtained from State Bank of India. My lord, we agreed. A master service agreement, my lord, was entered into between the parties. My lords get that, my lord, at page 141. 141, my lord. At 147, my lord, the 141 to 147 are all stamp paper, my lord. 148, the actual thing starts. Sorry. Lord, the relevant portion is at 179. If it is, my lord, the loan is foreclosed, they'll have to pay, my lord, 2% foreclosure charges.
179. 179, my lord. 179. Yes, my lord. What happened was, the State Bank of India, my lord, we remitted, my lord, the amount of 37 crores. My lords, my lord, get that at, my lord, running page 77. We remitted entire loan amount for closure of respondent's loan with the State Bank of India. ₹39 crores, 97 lakhs, 89,999, my lord, was sent by us, my lord, by UTR to State Bank of India. Thereafter, my lord, the State Bank of India, my lord, we also asked them for credit information. Page 79 onwards, my lords get that. $126, my lord. I'll not trouble your lords with others. 126. We also sought for credit information as sorry, 111, my lord, is the first one, and 126 is the second one. No reply was sent by, my lord, the State Bank of India. Ultimately, my lord, the State Bank of India, my lord, the respondent goes before State Bank of India, and my lord, he, my lord, did not want to pay the foreclosure charges. So, my lord, he has informed, my lord, State Bank of India that he would like to continue with them only. My lord, page 80, State Bank, my lord, writes a letter to us. At 81, sorry, 80, my lord. They return the entire amount after about about 1.5 months. 80, my lord. My lords may come to, my lord, 81. I'll not trouble your lordships with others. Please look at the second unnumbered paragraph at 81. Accordingly, as mandated by them, that's, my lord, the respondent, write their debit authority letter dated so and so, along with the check, to debit their account towards repayment to the closure of Kotak Mahindra Bank. So, my lord, SBI, my lord, returns the amount. Ultimately, my lord, we said, my lord, you'll have to pay as the foreclosure charges in terms of the mandate, my lord, agreement that we have entered into. That, my lord, was challenged before the learned single judge. My lord, we are a private bank. Therefore, my lord, first of all, my lord, the writ is not maintainable. This honorable court, as well as the Honorable Supreme Court of India and Federal Bank, has held writ is not maintainable. Learned single judge has not considered that. Secondly, my lord, the learned single judge has also noticed. SBI says, you did not ask for credit information. My lord, we asked for the credit information. They did not send it to us. Page 111 and 126, we specifically asked for, my lord, credit information. At any rate, my lord, not asking for credit information, my lord, cannot, my lord, invalidate, my lord, a loan that is given. And if they have not remitted, my lord, their own folly, they can't hold it against me. Courts have time and again held, my lord, that They went before, my lord, the ombudsman, banking ombudsman, my lord, he said that this is not. Therefore, my lord, they filed a writ. Learned single judge has allowed it. My lord, first of all, my lord, whether a writ is maintainable against a private bank, Honorable Supreme Court, my lord, has held a writ is not maintained. Federal Bank, my lord, Ombudsman, my lord, dismissed their application. They, my lord, went before the ombudsman, allowed the petition and said, my lord, I have to refund that. Yes. First of all, my lord, writ is not maintainable against a private bank, my lord, para 29. Secondly, my lord, the SBI contention is that, my lord, the learned single judge holds that credit information not having been given, the foreclosure, my lord, charges can't be. My lord, my submission to your lordship says, SBI, my lord, I asked for the credit information. My lord, can I persuade your lordship, look at, my lord, one judgment. Of course, my lord, one is a Rajasthan judgment, another is a Supreme Court judgment. Justice Navlekar, my lord, sorry.
And please, my lord, would your lordships be kind enough to look at the sanction letter that begins at page 57 of the appeal compilation? This is a sanction letter issued by the appellant, my lord, to me. Lord, my esteemed senior is right in saying that there was a facility I had with SBI. I did want them to take it over, but it was not entirely successful. I'll point that out. Please be kind enough to take page 57 for a minute. Begins at 57. At the bottom of page 58, my lord, second internal page of the sanction letter. Last but one paragraph. But that paragraph begins with the word, please note that this sanction letter, your lordships have that? Page 58 of the appeal compilation. Please note, page 58, my lord, of the appeal compilation. Second page of the sanction letter. Well, there's a table and below that, last but one paragraph of that Page starts with the words, please note that this sanction letter, your lordships have that? Last line in that. I can just read that last line. Further, your lordships have that, I'm sorry. No, I'm sorry. I have page 50, internal page number 2 of 18. It shows at the bottom of that page, my lord. The sanction letter was placed before the learned single judge by us dated 26/12/2008. It begins with the words, please note that this sanction letter.
Then 59, my lord.
I'm sorry, there's some pagination error. I apologize. I think they gave an unpaginated copy and then the page is some overlap. Sorry, sir. Page 59, last but one paragraph. Please note that the sanction letter forms an integral part of the master facility loan agreement. It is clarified that banks shall be entitled to vary the facilities so and so and so. Please see the last line. Sanction letter shall prevail over the master's facility loan/facility agreement. So therefore the sanction letter prevails. Please then be kind enough to see 62 perhaps, my lord, there is a list of other conditions. '63, my lord, I'm sorry, 63 other conditions your lordship should see. In that condition 12. I'm sorry if the pagination is a bit awry, my lord. Sorry for the inconvenience. Item 12, all facilities sanctioned shall be subject to the bank's rules as well as directives issued by the RBI. Now please see 2 pages thereafter. That would be at 65. This is important, my lord. Specific conditions. Pre-disbursement conditions, your lordships have. Pre-disbursement conditions, there is at page 65. Specific conditions. Please see, my lord. All norms of takeover should be complied. No due certificate should be obtained within 14 days of payment to SBI towards takeover of the facilities. Credit information report from SBI, ICICI Bank, South Indian Bank is a prerequisite for disbursement of funds. It's not just that they needed to take an information about my credit status. It is that they had to get this as a prerequisite. And this was admittedly not done. Then my esteemed senior pointed to a letter of the SBI. If I'm not mistaken, it begins at page 80. They specifically say that the manner in which you've disbursed funds, and my lord, what happened was they put the money that they were disbursing, 39 odd crores, into the account that I had with SBI. Page 80. My esteemed senior, my lord, read out from page 81. The same letter at page 80, they specifically point out and say, look, these are the terms that you violated. And therefore, what has happened is the entire money that they remitted into my account, which I held with SBI, was returned back by SBI to them. But normally borrowers come before your lordships and say some more time to repay. Here is a case where the amount was repaid in full by SBI itself because they had not, my lord, met the norms. Now, after the return of the money by SBI to say that they don't want this takeover by not the appellant before your lordships, they still try to debit me with a lot these foreclosure charges, saying you foreclose the account. My lord, it is not on my account. It is on account of their default, not mine. Not only that, my lord, learned single judge notices the fact that the entire amount has been repaid in paragraph 11 of the judgment. Lord, and coming to the maintainability of the writ, would your lordships be kind enough to take the judgment in Federal Bank that was tendered to your lordships? Please see paragraph 1 of that judgment and please see what the facts were. That was a case of dismissal of an employee and the dismissal being challenged. Or rather, suspension. I'm sorry, suspension, disciplinary inquiry, my lord. Let me be a little broad. Disciplinary inquiry against an employee was what was, I'm sorry. This in Federal Bank's judgment, which my lord was tendered to your lordships by on behalf of the appellant, the case was one of a disciplinary inquiry because there were some charges that were brought against a certain officer for granting loans in excess of his authority. Those are not the facts here. What we are seeking, we are not placing reliance on the judgment of the Supreme Court in Sardar Associates, or the compilation has been done. Sardar Associates, my lord, deals with the question of RBI guidelines. These are, my lord, pursuant to the RBI, my lord, master circular. But in Sardar Associates, the court, my lord, in paragraph 1 considers the power on the part of the RBI to issue circulars and guidelines. Of course, in that case, it was insofar as one-time settlement OTS schemes are concerned. Paragraph 38, my lord, there is a reference to what the effect of these guidelines are, and they refer to the judgment of the Supreme Court in Central Bank of India's case. And then, my lord, paragraph 42 at running page 15 of the compilation. Lord, what they hold is that in terms of the guidelines issued by the RBI, if a right is created in the borrower, we see no reason why a writ of mandamus could not be issued. We would assume, as contended by so-and-so, that we're exercising its power under 226. The High Courts may or may not issue such a direction, but the same, in our opinion, by itself would not mean that the High Court would be correct in interfering with an order passed by the appellate tribunal, etc. Then, my lord, in paragraph 43, they follow it up by saying, question pertaining to the present matter is regard whether or not a circular issued by a statutory body for governance and regulation of the certain agreements confers a legal right upon an agreed party or in case of non-compliance or complete or absolute deviation from the guidelines. Alternately, can agreed party claim a right of judicial review under 2032 or 226? That is precisely the case here, because there are, my lord, RBI guidelines which mandate that prior to one bank taking over the facility of another, they need to take the NOC and, my lord, all these other documents from the previous bank. It is somewhat akin to, say, my lord, one advocate taking a no objection from the previous advocate before entering appearance. It is somewhat akin to that. So therefore, in those circumstances, we are, my lord, seeking enforcement of those RBI guidelines to say that the imposition today of a penalty after the appellant not having complied, my lord, is not justified. That is, my lord, the submission that takes place.
My submission to your lordship says, please look at, my lord, the judgment, my lord, in Federal Bank itself. If your lordships take, my lord, the judgment that I had given to your lordships, paragraph 29 and 31, and, my lord, this judgment has been followed consistently, my lord, and there are enough judgments of our High Court where this honorable court has held a writ is not maintainable against private bank. Whether, my lord, it's a proceeding, my lord, against an employee, or, my lord, it is against the borrower. Ultimately, my lord, the short question for my lord's consideration is, would a writ be maintainable against a private entity? In fact, the latest judgment, my lord, in Maria school case, their lordships have held, if there's no public duty, my lord, there can't be a writ at all. Ramakrishna Math case, I didn't want to, my lord, unnecessarily burden your lordship with the authorities. Here, as far as, my lord, the judgment that my learned friend has cited, there was a right created. My lord, please look at, my lord, the RBI circular. Nowhere does it say, if you don't, take this, you are not entitled, my lord, you cannot, disburse the loan. The master circular is placed before your lordships. Nowhere does it say that, my lord, paragraph, page 269. Nowhere does it say that, my lord, if we ask, my lord, the authorities, yes, SBI for, my lord, credit information, they don't send it. Can, my lord, their own folly? That's why, my lord, if your lordships take, my lord, the judgment of Rajasthan High Court, my lord, in 1998, SEC online, my lord, Rajasthan, page 13, which I had given to your lordships, paragraph 7. His Lordship Justice Naulekar, my lord, as he then was, my lord, went ultimately to the Supreme Court. His judgment is there. Where, my lord, the Honorable Supreme, my lord, the
C.K. Nandakumar.
Only respondent.
No, RBI is.
RBI is there.
I am for the caveat, my lord, I think the first.
First respondent.
First, I was the writ petitioner before the learned single judge. Lodge.
You can hear 937.
Appearance matters, seal number 13, the B Vidyulata. Complainant.
The accused in this matter, Your Lordship. This is the same matter, it was to be complied by 2:30 on 13th, Your Lordship. And due to the paucity of time, the matter was handed over today. I've already served a copy. It has been complied with. The appointment order.
Has been. There is no dispute among the learned parties that the order under contempt is complied with. In that view, the proceeding does not survive.
I apologize that the
Right,
order has
also
not been
learned.
translated, Your Lordship. It was issued on 13th itself. It's in Kannada.
Learned Mr. Jafar Shah tenders memo dated 13/6/24 stating that the producing copy of the office memorandum dated 13/6/24. What is it? Appointment is given.
Appointment.
Whereby the appointment and compensation basis is given to the complainant.
Primary health center.
That the
Award.
directions are compliant with, nothing survives in the present contempt proceedings. They are closed.
Please.
Right.
Oblige. In consideration of compliance in contempt matters, seal number 14.
Just now, notice they have given a notice the memo showing that notice they have deposited some amount. That compliance. Notice may makes.
Deposited?
Just now they have served notice, we have to verify and not take. But they have served a memo stating that not they have deposited the amount. Notice.
Where is the memo?
Notice. Just now.
I'm apologizing, my lord. It's not translated, my lord.
Photocopy of check is there.
Yes. Notice. Here notice.
Following directions were received by learned single judge while deciding writ petition number 18266 of 18266 of 21 as per order dated 28/3/22 in this page 17 and 18 court. The amount payable under the award as per direction into bracket Roman 3 above, small Roman 3. Have been deposited or paid?
Deposited, my lord.
Deposited.
Deposited before the civil court, my lord.
As per the memo dated 18/6/24 submitted today by learned advocate Ms. So and so for the respondent. The memo inter alia states that toward the amount of, toward the award, toward the amount payable under the award, check dated 6/6/24, bearing number 552876 in the name of Registrar City Civil Court, Bangalore, for amount of rupees 3,03, 3,03,50,774 has been deposited. The communication dated 7/2/24, figuring on record in that regard, bears the acknowledgement of the City Civil Court as reflected from the stamp dated 14th June 2024. In the aforesaid view, nothing survives in the contempt proceedings. They are disposed of.
Notice, one more notice they have to comply, notice. That order, notice the first notice, page number 17, notice the first, notice the prayer. The petition stand disposal directing the development authority, the second and third respondent to complete the inquiry as aforesaid within a period of 12 weeks from the date of receipt of a certified copy of the order. Notice they have to intimate that, notice to the, notice this complainant hearing. Since, notice the completion of that inquiry and notice the result of that inquiry has not intimated to notice complainant.
Inquiry is not required.
Not they conducted them, not the inquiry and not by appointing a special task force.
Inquiry is not completed.
Not they have not intimated the result of not that.
I will seek instruction, my lord. My lord, one revenue site holder has filed the writ petition, my lord. Yes.
Grievance is raised about non-communication of the outcome of the inquiry by learned referee for the complainant. Post of responding to this, it was stated by learned referee of the respondent that the necessary communications will be sent within 2 weeks. Necessary communications shall be sent to the within 2 weeks.
Please.
There is a provision in the not of the BDA Act to provide them not of the
Necessary
developed site not of
intimation
60,
shall be.
60 into 40 not.
As there is substantive complaint, nothing remains in the.
Number 15, the Shivraju MP.
Respondent filed affidavit in complaints of the stating that there is no allegation against, there is allegation against the Tahsildar. Tahsildar not at all informed the letter to the respondent office. That's permitted to made a party in the Tahsildar mill.
In this case, after passing of the single judge writ petition order, my lordship, I sent the letter to the Tahsildar to verify the.
Right with or not?
Kindly see the annexure R3. I already issued the endorsement also.
Yes.
Kindly see the annexure R3 in page number 18 of the counter update. In this endorsement, my lordship. I'm already issued the endorsement to the complainant.
Where is that?
Genuinity
Section
of
R3.
the learned single judge passed an order to effect kata in favor of the respondent. Genuineness of the Akkupatra issued by the Tahsildar. Now they are saying that sent a letter to the Tahsildar, but the Tahsildar not at all informed it till today. Hence they
In
are
this-
saying
in
that.
this case,
Hence
kindly
may-
kindly
permitted
Read
to
the directions.
Kindly
Petition is
permit, kindly permit.
directed to appear before the respondent 4. Who is number 4? Tahsildar.
Yes.
On 4/7/20, you appeared
Appear mal.
and furnished the original Akkupatra. You produced the Akkupatra.
Akkupatra produced before the.
Respondent 4 is shall, after making a photocopy, return the. So this is the only direction. What is it?
Kindly see my lordship, page number 22 of the my counter.
Proceed to register the khata in name of the petitioner. So what did you do?
Kindly see the R3 my lordship, endorsement issued by the Panchayat. R4 my lordship, sorry. Page number 22. Translated copy. Endorsement date 23/1/2023 regarding issue the endorsement of for the application received for registration of kata in respect of title deed of site number 55 granted under Ashaya scheme in survey number 116 Tarbanalli village submitted by Sri Narayan Swami son of late Dodda Venkatappa. As concerned as aforesaid subject, your Narayan Swami son of Dodda Venkatappa has informed that the title deeds have been issued under Ashaya scheme in respect of survey number 116 in the Tarabanhalli village and appealed for registration of the Kata by submitting the title deed and copy of the order of honorable court along with the application to Gram Panchayat. The said application has been examined, Honorable High Court as directed to consider the application by examining the genuineness of the title deed. As per this letter has been written Tahsildar Yalanka to provide the report by examining the genuineness of the said title deed. As per the reference 1, Honorable Tahsildar Yalanka has informed to Honorable Executive Officer Yalanka to collect the information for Meenukunte Gram Panchayat by examining the genuineness of these title deeds, since the file in which said title deeds are distributed is not available in his office, but it was not possible to collect the information since no file is available in Meenukunte Gram Panchayat in respect of sites of Ashaya scheme in survey number 116 in Tarabanhalli village, and since said title deeds are issued from Honorable Tahsildar Bangalore North Taluk. The said documents concerned said title deeds are available in office of the Honorable Tahsildar North. Therefore, the letter has been written to Honorable Tahsildar Bangalore North Taluk City as per reference 2 in order to give clear opinion about the genuineness of the said title deeds. Hereby inform to you that your application will be considered after clear opinion received in respect of genuineness of the said title deeds. Kindly see the order passed by the single judge, Malaship, page number 14 of the order, Malaship. Page number 14, para number 8, Malaship. In that view of the matter, the writ petition is allowed in part, the impugned endorsement bearing number so and so 16/2022 issued by the respondent number 4 is quashed. The respondent number 4 is directed to reconsider the case.
Your vehicle without brake. Which
So,
page?
yes, Minister. The
Which
the
page
Tahsil.
is it?
Sorry, how page is it? In a contempt petition, page number 14 of the single judge order, Malaship.
Where is the order if you have passed?
Order has been passed by the.
Where is that order?
Kindly see the page number 14.
14. 14/8/23.
Page number 8, Minister.
14/8/23.
Yes, Minister.
Page number 8.
Page number 8 of the 8, Minister. Page number, para number 8 of the judgment, Minister. Page number 14.
14, page number 14. 14/8/23.
Yes,
Office of Yellahanka Taluk Panchayat. Same?
yes, Minister.
Read it. What is it about?
Hello. I am reading.
Tahsildar has received information from record room. This file in which the title is issued is not available in the office. All Tahsildar. This we are not satisfied with the defense.
In this case, Malaship.
Tahsildar responsible shall remain personally present to explain the statements made in the endorsement that the files are not available. It doesn't inspire confidence. When he will remain present?
In this case, Tahsildar has not made a party, Malaship. Tahsildar has not.
We are asking him to remain present, whether a party or not. It is your duty to call him.
The government, Malaship.
Yes, call him on 1st July.
Number 16. Mr. Vaishali, agree?
This is a direction to carry out 4D and tourist of the granted land. Now they filed a counter stating that the original grant certificate is not there and their records are missing, and therefore they have sent it to the reconstruction.
document is not available, my lords. We have referred it to the missing committee. And the result of the missing committee is awaited, my lords. The grant certificate itself is not available.
So when will be reconstructed?
That's 4 weeks' time, my lords.
4 weeks.
Please, Your Lordship.
It was stated that in order to, that the order could not be complied with since the original record was missing. It was further stated that the reconstruction committee has directed that the records will be reenacted,
Lords,
which may take time, put up after 4 weeks.
Lords, reconstruction committee will consider all the circumstantial documents and give a report.
So far not direct,
Lords, it's placed before the missing committee, my lords.
simply 4 weeks.
Please.
Don't write time. At the request of learned additional government advocate, Ms.
Pramodini Kishan.
Pramodini Kishan, stand over to 18th July.
Moving on into the applications, December 17.
Appear for the petitioner in this matter, my lords.
Appearing
On the
for
last two dates, the Council for Government had produced an inquiry report before this honorable court, a sealed cover. My lords did not produce a translated copy, my lords. So we require some time. We required some time for it to be translated before this honorable court. It's in Kannada document.
State had filed a report, my lord, and by virtue of order dated 18/3/24, the report was produced before the court in a sealed cover. And liberty was given to the parties to take a copy of this
Certified
report.
copy.
It is a PIL.
It's a
PIL.
PIL matter.
Regarding?
Regarding against the Karnataka State Judicial officers.
Respondent number one is the
Respondent number
cooperative
one.
society, my lords. They wanted an inquiry into the affairs of the society.
For allotment of sites, which they claim has been done irregularly and without following the bylaws.
No, 2007, anything.
Had
sir?
raised on the maintainability, my lords. They have to raise a dispute before the registrar, section 70 dispute
Section 70.
before the registrar.
But the
Karnataka Cooperative
Karnataka
Societies.
Cooperative Society.
Societies Act.
We had raised, my lords, that maintainable. In the meantime, my lords, this honorable court directed for an inquiry. Even that is done now. They have, that has to be followed in accordance with law. The inquiry, if there is anything in the inquiry that needs to be done, the competent authority is the registrar of cooperative society, my lords. He has to take it forward.
We have the certified copy of the inquiry report, my lords. We need some time for it to be translated. Since it's a Kannada document.
2007 will not grant time. What is this order dated? Long order?
For the inquiry, they.
Inquiry to be conducted.
3rd June.
The registrar did conduct an inquiry.
And
the
that has
report is
been
before your lordships.
Petition is disposed of.
It's not disposed.
Not
That was disposed, then again it was revived, my lords.
The inquiry report is of 6/2/2021.
We'll deal with and finally decide this on Thursday.
I have filed an application for
Yes.
impleading, my lord.
You come after. After 15
Yes,
years,
my lord.
so nobody should be.
One of 24.
Only order will be implemented, yes. We'll. You want to
I have
submit
filed an
translation?
application to implead.
Translation you want to submit?
13 applicants, my lord. They are the
Translation
associate
of the
members.
inquiry report, my lord.
Inquiry report.
Inquiry report.
Inquiry
When you will
done.
submit?
My lord, the government can give us a copy of the translation.
It was there on.
It's already placed.
We will apply for the same one. We'll apply for a certified copy of this.
It is already there.
Yes, yes, my lords.
My
There is
lord.
an order with this honorable court. Whoever applies, they can be.
The order is
We got
dated
it, my lord.
18/3, my lord.
This honorable court.
26. On 26 will be able to give?
Yes, my lord.
26.
By 26, hopefully we should.
Obliged.
December 18.
What's up?
Mr. Kalimullah Sharif.
It's a mistake in my petition also in the file, that's why I have filed this application. I have already filed a revision petition before the secretary, my lord. I may withdraw the application with the liberty to proceed with the revision, my lord.
What about this?
Pardon, my lord?
What about this?
Withdraw the application, my lord. I will proceed with the revision, my lord.
Learned advocate, Mr.
Kalimullah
Sharif seeks permission to withdraw the present petition stating that the petitioner has filed a revision application.
I have filed revision.
Before the competent authority. Permission is prayed for is granted, the disposed of as withdrawn without expressing any opinion on the merits of it.
I will proceed.
Proceedings of revision may proceed in accordance with law.
Number 19. Mr. Ravindra Gajanan Pillai.
Please, my lords. I have filed an amendment application, my lords, at IA number 5. And the other day, learned government advocate across the bar delivered me a copy of the communication. And based on that, my lords, I have sought for an amendment producing the same as Annexure V, my lords. I have also sought to include 2 grounds at serial number 14, 15, and 16.
We want amendment, amendment granted. IA number 5 of 24, amendment is prayed for in the main petition by filing this interim application.
I will carry out during the course of the day.
Amendment, it could not be said that it changes the nature of the main controversy or introduces a new case, therefore amendment could be granted. IA is allowed, paragraph. Amended copy of the petition shall be supplied within 1 week.
My submission, my lords, since urgent orders are needed, my lords, for the last 8 months, my query is totally stopped only because of this communication.
Amendment, then what can?
Today I will be carrying out, my lords, maybe posted this week or possibly in
Why
the.
your query is not permitted? Why your query is not permitted?
Because question is that they have requested the government to take a decision. And it is the deputy conservator of forest has requested.
No, it is the forest,
Sorry, I would submit that, madam, there is no such.
There was a
order.
communication by DCF to obtain forest clearance from MOEF. That they have not challenged.
It is not a forest land at all. It is not even a forest reserve. There are no documents forthcoming to say that it is a notified forest land.
When do you want, when will you carry out the amendment?
Today itself, I am ready with that, my lords, maybe.
On 2nd of July.
Please, my lords.
Number 20. Non-filing in contempt matters, Jagdish DC, the complainant.
I have read a memo to delete accused number 2. Accused number 2, I have filed a memo.
What?
Because I need to file my. Reply is not filed despite giving sufficient
Shall
time.
For the 3rd July.
And regarding memo for deletion of A2 may be ordered. I will delete.
Not 3rd July, little longer. 11th July.
Number 21. Srinivas V.
For weeks accommodation. In the meantime, I'll file.
12th July.
Number 22.
For petition, my
Suresh.
lord.
9th June, actually, 9th June, my lord, I have filed my affidavit, my lord, to the effect, saying that, my lord, the alternative site was found out. And my lord, the local residents, my lord, there, they filed an objection, saying that they want that particular site for puja, my lord. Certain time is granted, my lord, we will allot some other site to the petitioner, the complainant. I filed an affidavit to that effect. It's already 13 months is over, my lord. 13 months is over.
When you will
That
give?
We will allot the site, my lord. In fact, the site was identified. And the locals, my lord, they filed an objection saying that the particular site they wanted for puja ceremony. So, my lord, we are now looking out, my lord, we'll definitely file, allot a site,
Within
alternative
what
site.
time?
For 3 months, my lord. 3 months, rather than 13 months.
You have filed your,
We'll make, your lordship may
Thanks.
give us
some replies filed?
I filed my affidavit also.
Where is that?
The office shows that I have not filed, but my lord, may I pass on, my lord? I have one more copy. Signed, my lord, the same was filed on 9th June itself. 9th June last year.
So what he lost his property?
My lord,
You lost your property.
it was his property, my lord,
Actually, they have taken in the year
acquired
2000.
it for a park, my lord. It was a part of the park. It was acquired, and thereafter, my lord, we
Oh,
could
so he has
not.
already lost his property.
In 1992, they have acquired my site to construct wall to the Prushabhavati Nala, not for this thing. 92, not now. It is already 45 years is over. So order has
Now
passed
the-
2022 to give alternative site.
Alternative site was found out, my lord, two
Court
alternative
is not
sites.
satisfied with the compliance affidavit. Will the property of the complainant, the complainant is deprived of his property since 1992. In lieu thereof, the site is to be allotted. Full stop. It is duty of the respondent BBMC and its officers to act swift and ensure that the alternative site is available to the, made available to the complainant within a reasonable time. Full stop. In the paragraph, in the compliance affidavit today, it is stated that though the proposal was mooted for allotment of alternate site, it could not fructify for want of various reasons. Full stop. Be as that it may. Full stop. Learned advocate for the respondent BBMC wanted 3 months' time to comply with the directions which cannot be granted. Full stop. The directions will be complied with within 1 month, and the alternative sites will be granted to the appellant. Put upon, today is what date? Put upon 5th August.
5th August.
5th August. By that time you do that.
These 2 months, something will be done, my lord. I've talked. 2 months' time may be granted, my lord. Once for all, it will be over.
You've given more than.
Much appreciated. Slowly.
இல்ல சார் சைன் இன் கொடுத்தா போதும். சைன் கொடுங்க சார்.
Lordship, kindly, serial number 73, Your Lordship. Posted for direction actually. Earlier it used to come in the top of the list. Matter pertained to the rejuvenation of river Vishwavati River Valley, which was flowing in Bangalore earlier. And because of all encroachment, it is not now there. Only beyond that it is going. And a specific order was passed on 28 July 2022. After survey is conducted by the government revenue department and as well as by the NERI report, National Environment Agency. Based on that, the report was required to be submitted by the BBMP, respond number 2. Even again, another direction was given on 5th December till 2023. Even now, they are not complied with any direction. Some convenient date, it may post it top because earlier it used to come in the top of this for direction, under direction. Not today, some
Date must have been given.
any,
No, it is posted on some date.
yes,
Which date?
yes,
It
It's
is, date
listed.
is already given or not?
yes.
Which date is given?
Pardon?
It is already posted on some date?
Yes, sir.
On which date?
Date, any
It's
convenient date next.
No, now it is.
listed today, my lord.
Any date is.
It's listed today at serial number
Date is-
73.
Serial number?
73, Your Lordship.
73.
Seven.
For direction it is.
So whenever you want. 2020.
The last order is when BBMP was directed to file a report, my lord. That's what the petitioner is saying, that they haven't filed the report till date.
But
Is
BBM,
Regarding what?
Encroachment of riverbed.
Whenever you want.
any convenient date, because so that it can be, because BBMP is not filing the report at all till today.
8th of July.
Specifically, the order was passed on 28 July 2022. Your Lordship.
8 July. 8 July.
$79.
On behalf of the appellant, your lords, I filed memo for withdrawal in the matter.
Learned advocate, Miss
Shivani Shetty.
Shivani
Shivani Shetty.
Shivangi
Shivani, your lords.
files memo dated so and so, which reads the agenda. Where is it? Copy of the request forwarded to memo upon instruction to withdraw the petition. The permission is granted, the petition is dismissed and withdrawn. Appeal is it. Court fee, court fee is paid or not paid?
It is not paid, your lords.
Seal number 80.
Appearing for the
Lordship, may I
state, my
kindly
lord.
take it up on Monday. I've got the signatures of the clients in the memo for withdrawal. 2 more clients, I have to take their signatures. They're people's representatives, so I couldn't get in touch, your lordships.
Monday.
3 people have signed, 2 more have to sign. Maybe taken up on Monday or Tuesday.
Whenever you want, Monday,
Next week on Tuesday, your lordship,
Tuesday to Thursday.
please.
Tuesday in the morning.
Please.
Seal number 23.
Yes, the compliance affidavit is ready, my lords.
The order, my lords, was to deliver back the land that was illegally taken possession of, my lords.
As per the directions, the survey has been conducted, my lords.
Your lordships may see page 31, my lords, of the petition.
What did you do?
Lords, the direction was specifically to hand over possession. Page 32, my lords, in page 12, para 11. possession to be handed over by the government within a period of 10 days from the date of receipt of certified copy of the order by drawing a mahazar in presence of the petitioners and other affected parties. We have given in numerous representations till today, my lords. They say we are going to conduct survey. All those was different.
My lords, after the survey, it is found that the land has been encroached by the complainant, my lords. And we have, as per the directions of this honorable court, we have initiated proceedings before the Land Grabbing Act also. Now the matter is pending before the Land Grabbing Act. Lords, it's a vacant site.
It's not
So,
a vacant site.
it's a
my lords.
vacant
They had
site.
demolished 55 sites. That was the grievance of the petitioner, my lords, before this honorable court. My lords may look into page 31, where detailed orders were passed by this honorable court. Para 8 onwards, my lords. The Tahsildar, my lords, who had no authority under law, demolishes, my lords, without even notice to us, 755 site owners, my lords. We have produced the photographs where we said certain political people were involved in this. Page 68, we have even produced a Instagram photo of a politician, my lords. Page 68, who was interested in getting all these areas demolished. We have even produced page 68. Looking into this, my lords, the honorable court, the single judge, my lords, said hand over possession, conduct a survey. If at all there is encroachment, it has to be by the special court.
Exactly what we have stated in the compliance
But
affidavit.
first, within 10 days, they had to hand it over, my lords, the possession to us. That they have not complied. The special court has not come to a conclusion that we have encroached. It is still allegation by the Tahsildar, who has no jurisdiction in the matter, is what this honorable court has said, not in one matter, my lords, in a batch of matters. Kindly see, my lords, page para 8, page 30. Page 30, para 8, my lords. This honorable court's orders. Taking note that the present properties of the petitioners in the form of sites are part of old survey number 175 of so-and-so, which government claims to be new survey number so-and-so, noticing that in another petition, insofar as the same village, order is passed and observations are extracted as above. The present petition is also to be disposed of in the terms, same terms. Accordingly, the notice at annexure Q is set aside. Liberty is reserved to the respondents to take action as per law in terms of provision of Karnataka Land Grabbing Prohibition Act or as may be permissible under the provisions of the Karnataka Land Revenue Act so-and-so. Accordingly, the petition is disposed of in terms of the following. The revenue authorities to conduct survey in presence of the petitioners with reference to the revenue records and survey documents maintained with the Assistant Director of Land Records. Upon the sketch being prepared pursuant to the said survey, and if it is found that the government land is encroached, the respondents are at liberty to take appropriate action in terms of the directions made in so-and-so or other action as permissible under law. Needless to state, the survey to be conducted in the presence of the petitioners and all other interested persons after notifying the date in advance and sharing the copies of the survey or revenue documents to the petitioners and other interested persons. In light of setting aside of the notice at annexure Q, the possession said to have been taken away by the Tahsildar pursuant to annexure Q is to be restored to the petitioners. Learned counsel for the petitioner seeks liberty to initiate appropriate proceedings for damages. It is for the petitioners to work out that was other thing, my lords. Para 11, possession to be handed over by the government within a period of 10 days from the date of receipt of certified copy of the order by drawing of mahazar in presence of the petitioners and other parties. My lords, they had to hand over possession, and afterwards, my lords, they had to conduct survey. And if at all there is encroachment, my lords, they had to, my lords, similarly placed persons, my lords, had filed another petition where, my lords, this honorable court had held that the Tahsildar had no jurisdiction to demolish and take over possession of any lands, even if it is encroached. At page 28, my lords, that order is also called out by the honorable court. Para 7. It is noticed, para 7, sub para 2, my lords, it is noticed that in terms of the order at annexure B, the Tahsildar has found that there is encroachment of government land with respect to the land to an extent of 6 acres, 7 guntas in new survey number 416, old number 175 of Baglur village. So and so, so and so. And it is directed for recovery of possession of such encroached land. Learned counsel appearing for the petitioner submits that the Tahsildar has no jurisdiction to pass such an order pursuant to the notice at Annexure A, as action for recovery of land encroached by private parties will have to be done by following the procedure under the provisions of Karnataka Land Grabbing Prohibition Act 2011, when such government land falls within the jurisdiction of the authorities specified under the Act. It is submitted that the officer concerned is required to follow the procedure under the Act if the officer is of the opinion that there is encroachment of the government land. Learned additional government advocate submits that the procedure under the Act ought to have been followed, and one specific procedure is provided under the Act.
The directions are at page 31 of the writ petition, my lords. The first A, B, and C have been followed. Now, there is nothing on record in the writ petition to state that there is demolition as such, and there are no directions with respect to demolition. So,
We are concerned with the directions regarding ending our project.
my lords, so far as the directions in A, B, and C have been followed, my lords. So far as restoring the possession, my lords, will take instructions, my lords. I'll produce the document if the possession has been restored. So far as
What kind of encroachment is there?
My lords, we are, my lords, purchasers of sites from the year 2006, 2007 in survey number 175. Now government says, which was 20 acres, 28 guntas of land. Now government says it is survey number 416. It is within a layout of 80 acres, my lords. It is saying it is 416. We have made innumerable representations asking them, please give us what is this new survey number 416, which has come into existence after we have purchased sites. How can it come into existence? We are all site owners, my lords, middle class people, and kindly see what were the small constructions have been demolished, my lords. Just like that, they got in bulldozer and they demolished, my lords. They were all small people, my lords. It's not that they belong to an affluent class.
11 persons have to be ended over some site.
55 sites were there, my lords. In this, 55 sites are there. 55 sites area has been encroached, has been taken by the
the
government.
society, it's a society site, my lords.
Society-
It's our case that the society has encroached, and after encroaching the land, the society has given away the sites to its members.
You challenge,
But
either you get clarification, modification. You did not point out anything.
It was argued, my lords. Everything was argued. The honorable court heard them. Then this honorable court, my lords, felt that it's the Tahsildar. Just by looking into the records, my lords, he cannot come into the conclusion. It is the land grabbing court, which is a special court for such encroachments, my lords. They have to prove it in accordance with law. They have to produce material. My lords, we have made so many representations asking them, show us how survey number 416 popped out of survey number 175. They did not even produce those documents. That is why this honorable court, my lords, said, in fact, we had asked for 50 lakhs of compensation, which this honorable court said, I won't look into.
But the specific instructions about.
my lords, so far as these
Anybody is present?
directions, my lords, to major extent have been.
Anybody is present?
No,
Your officer is there.
officer
Take
is-
instruction.
Please,
Call him if necessary, for your purpose, not for our purpose.
or
Even today, notice was not given to us. As per the directions, my lords, my learned friend is saying, we surveyed after giving us notice to 55 site owners. No notice was given even today. I can
Lords,
put it on
Lords,
note.
I will
And
clarify
they
on
have
that.
not, my lords, given us any records. There is at serial number 3, there is specific directions by this honorable court to give us the records. My lords, we were requesting the government to give us the records. How did this
Yes, there
survey
were
number come
12
into picture
petitioners.
after we purchased the sites?
There were
Yeah,
12
you-
petitioners in the writ petition, my lords. We have issued notice to everybody, all 12 of them. Only 6 of them were present in the spot inspection on the survey, on the day of the survey. And we have also recorded the Mahajar. It is all produced before this honorable court, my lords. So without seeing the documents, they cannot submit that notice was not issued. We have issued notice, a date was
Kindly-
fixed. Lords, Mahajar was conducted, all the officers were present. We have enclosed even the photographs of the spot inspection and the survey that has been conducted. And now it is found that there is encroachment, and we have registered a case before the Land Grabbing Act.
Kindly see, my lords, subsections, subpara C. needless to state, the survey to be conducted in presence of the petitioners and all other interested persons after notifying the date in advance. My learned friend is saying 12 petitioners. We were before this honorable court. We told them, because the notice was given on just the previous day, and even before we could even reply to the notice, they demolished the structures. We said 55 people, they were all old people. Many of them could not come before this honorable court. I even requested the honorable court, grant me 2 more days, I'll implead all of them. This honorable court said, no, not necessary. They will give notice to all the people, all the 55 people, and conduct survey only in presence of them. But we will hand over the possession immediately. That is what is the order of this honorable court, my lord. First possession was to be handed over to us within 10 days.
Lords, notice, my lords, we have produced the notice also. It was issued on 11/12.
Call your officer.
Please,
Then
ma'am.
find out, then make submission.
Very well. Very,
27.
27. Please.
Oblige, my lords.
Number 24.
Please.
Balgangadhar G.S.
Notices were issued, my lord, with regard to payment of the benefits and, my lord, the promotional avenue. The directions of the Honorable Division Bench, my lord, is not complied with. Their SLP was also dismissed, review was also dismissed. Notices were served, my lord. I pray the Honorable Court, my lord, to issue the notice, my lord, or warrant, my lord, as the case may be. All of them are served.
So who appeals?
That notices are served, they have not entered appearance, my lord.
Served.
All are served.
Those served with the notice of this court, none appears in this.
Please.
None appears on behalf of the respondents. So these are the contempt proceedings. Paragraph. The petition may be, contempt petition may be listed on next on 26th, on which date, unless the respondent appear through advocate or pose appearance. Otherwise, appropriate order shall be passed in accordance with law. Post of registry shall intimate about this order to the respondents.
Please. Date.
26.
26.
Number 25. To Venugopal MS.
Yes.
The compliance report is ready, my lords. I'll get it filed. Serve the copy.
You complied with? Check it up. Representation. Phada.
The direction is to consider the representation, my lords. It has been considered when an endorsement has been issued.
What is to verify? There is an order. What is stated in the order? Very fair order. You want to take instruction? Monday? Monday at 2:30. Learned additional advocate, government advocate, files compliance affidavit, which prima facie shows that the direction of deciding the representation, which is under the contempt jurisdiction, is complied with. Paragraph, learned advocate must so and so for the complainant press for time to verify about the factum of compliance. Stand over to Monday is what date? 24th? 24th at 2:30.
This is number 26. Vaishali Agre.
Therefore, the complainant, my lord.
Here for the accused, my lord, I have one submission to make, my lord. This was a writ appeal that was filed that is listed as serial number 42 today, my lord, on the very same matter. The writ appeal was filed on 10/5, right after the vacations, right actually during the vacations, my lord. Notice was issued was ordered by this honorable court on 26/2, my lord. And thereafter twice it has come up before your lordships, however, has not reached due to paucity of time, my lord. Meanwhile, the complainant has filed this contempt petition, my lord. So the writ appeal is pending before this honorable court. Notice has been issued. The copy has also been served on the other side, my lord. The matter needs to be
Writ appeal
heard.
is pending.
My lord?
Writ appeal is pending?
Yes, my lord. Today at serial number 42, it may kindly be connected with this matter itself, my lord.
So both will be listed together on day after tomorrow.
Obliged.
This is number 27.
We have complied, your. Direction is at page number 28.
What is it about?
Lords, the direction is at page 28, clause 5. Lords, to release the iron ore. Of course, this order was questioned before the Honorable Supreme Court. And the Honorable Supreme Court, my lords, dismissed the SLP, my lords, on 17/5/2024. Just placing that order, if your lordship sees the order.
What are you?
Then, my
what is-
lords, then, my lord, what happens is, the learned single judge had only directed. The Supreme Court has dismissed the SLP, which your lordship supplied. Now, the operative portion is at clause 5 at page 28, where the learned single judge had directed us to furnish one surety and indemnity. Now, my lords, what the officer is now construing, if your lordship sees, he wants a property to be furnished. Now, that is not the indemnity is there. Surety is somebody who can stand surety. Now the officer is insisting on a property to be furnished to the value. That was never the condition of the code. Because it does not say surety to the like sum. It only says indemnity to the value and a surety. Surety, my lord, somebody who can always stand and give a surety, who has, of course, property in Karnataka. But it does not mean, my lords, that they demand a property of the value of the vote. Your lordship may kindly see page, along with our memo, we have, my lords, enclosed another letter of the range forest officer on 11/6/2024, where he says, we are eager to comply, but you give us the property details and get a valuation of the property.
So, Mr. Mahindra, this, it doesn't speak of solvent storage. Then you can be justified in demanding the property.
May I read the direction in page number 28, class 5. The Assistant Conservator of Forest, Ankola, Uttara Kannada district shall determine the actual quantity of iron ore available which was stocked by the petitioner, and also determine the value of the iron ore. And upon determination, the range forest officer shall release the said quantity of iron ore to the petitioners with one surety each, and on executing of indemnity bond by the petitioner for the value determined. Now, my lord, all that the range forest officer has done was, he had issued a notice, producer document number 1, calling upon the petitioner to furnish surety as directed by the learned single judge, and quantification is also done. That was enclosed along with the notice. Last, may kindly peruse page number 3 of the notice. Further quantification valuation report, quantity valuation report of iron ore measured has been received with a reference number so of this office. Therefore, you are hereby intimated to approach range forest officer, Ankola range, for further necessary action with indemnity bond, a surety for the value of the iron ore as mentioned in clause 5 of the Honorable High Court order dated 25/9/2023. The details of valuation report from the office of the senior geology, Department of Mines and Geology, Uttara Kannada district is attached. We are asking surety as per the direction.
Surety does not say, my lords, for value, with great respect. It is the indemnity bond for the value. The word used is and.
This release order was made in a pending criminal case. That case is still pending before the jurisdictional magistrate.
We are not there.
We are not able to believe that you are not able to offer the, we are not ready to believe that you are not able to offer the surety. Like, you release the quantity or not? Iron is released?
No, no, it is
No.
not, because they are asking if your lordship sees the further letter which we have produced on 11/6, which is along with our memo at page number 4. They are saying give the property details as a security.
See, Mr. Phanindra, it reads like this. Forest officers has released the quantity of iron ore.
With
the
one
petitioner,
surety.
One surety each,
There were two petitioners, my lord. That's why one surety each is.
and on,
Executing of indemnity bond for the petitioners for the value determined.
so one surety each goes to the individual.
Well, it's one surety because there were two
Surety
petitioners.
and
Right now, before my
indemnity
lord,
bond each,
that's what they
for
were.
each, one of,
You are given which type of surety?
Well, it's the surety, when we go with the documents, they say, give us property surety. Property to the value of the ore. That is not even there. I can only give an indemnity to the value. But if your lordship sees 11/6/24 notice by them, they say you have to give me
no,
security.
indemnity is personal indemnity,
That's all.
they give, lord. So far as to secure the value of the mineral
So
to be
court is
released.
not, court is directed, that is enough.
The court's direction, they have challenged it. They have.
To that extent, they have to furnish surety.
There is,
You challenge it.
they challenge before the Supreme Court, my lords, all these things. Supreme Court says this is all what is required.
No, no,
Now to say surety to the like sum,
no, no,
then my
we-
lords,
we have-
indemnity and
We
surety
have
will.
challenged the entire order.
Very
It is not to the extent of
I
furnishing
understand.
surety or indemnity.
Lords, if I have to give a security for the entire value, the question of indemnity will not even arise. That's the understanding, my lords, which we have to, and the court has consciously recorded and non-executing indemnity for a like sum or for the value determined. Now, I am willing to do both, but if they want security, my lords, with documents of a property, in fact, we gave documents. Now they say, get it valued, get it this, get it translated,
No,
all that
even-
is for me.
Even in criminal proceedings, lord, whenever a vehicle is released as an interim measure, the court will ask for surety and indemnity. Surety to the extent of value of the vehicle.
Here it is not given.
It
No,
is-
because my
now
lords,
we have
when
asked
I
them
go
to
with the
fur-
surety, they say, give me security of a property. I will give surety, but not sure, my lords, I can understand. And CBI has said there is no case against me. That's the categorical finding by the CBI, not even the state.
You have determined the actual quantity.
Yes.
Value also is determined, quantity is determined.
So far
Now,
as
because it
that
was
part of
pending in
the
the
order
honorable-
is concerned, lord, we have complied with the order. There was a direction to quantify the iron ore, that has been done. Now for release of,
Was there to quantify it.
yes,
So accordingly, we quantify.
yes,
Still you are remaining 25 lakhs. What
Six
difference?
for
is-
release,
crores, 95 lakhs security, which the court has not even asked. Please see page 5, my lords, in my memo, their communication dated 11/6/24.
So then we direct, you do it or the remain present. Either you do. You comply with.
Lord, in order to comply, Lord, they have to furnish surety. They are furnishing surety of Tamil Nadu. Lord, to that extent, they have to furnish. The purpose of Lord insisting surety is to.
Surety they will furnish, but not solvent surety.
Not so.
That's all.
Solvent surety they have to furnish.
No, where is that word?
Even otherwise, Lord, the purpose of insisting surety is to secure the.
Then get clarified, get it clarified. Get it clarified.
Otherwise, my Lord, it becomes mere formality.
Get it clarified. We'll put up for 3 weeks.
Please, let them move for clarity, because this point was, I know, it was urged by the state public prosecutor, and how it was worded.
4
we know.
weeks time may be granted, my Lord, we'll get it.
18th July.
God bless.
May record, my lord, they'll move for otherwise after it, when it comes on 18th, they would have not moved also for clarification.
You are right, but they are.
Number 29. Number 28. Srinivas K.
This is regarding, my lord, on the implementation of the order passed by the Sambu Court, wherein direction
Take
was
some
issued for
time, my lord.
the granting of one increment for the last year of service rendered by the employee. That's the complainant's hearing. The matter, my lord, was also taken up before the Honorable Apex Court, which also, my lord, dismissed the SLP filed by the accused.
Lord, my instructions are from the department that post completion of the writ petition, writ appeal and suffering an order at the hands of the Apex Court, the finance department has sought for some clarifications which need to be filed before the Supreme Court. A review petition is already filed here on
12th July.
maybe another, because we have already filed, maybe first week or something, we are going to get it posted before the Honorable Apex Court, maybe 15th or post 15th, my lord.
In other cases, they've already implemented the order. Only in case this our case, my lord, they-
19 July.
Yes, 28, 29 are similar matters, my lord, arising out of the same order. Deeply obliged.
December 30. Nitin Prasad.
For the complainant.
My
Not just this
objections are ready.
afternoon. not- I
My
was served with a
objections-
copy, my lord, of the counter affidavit just before lunch, my lord. I'll go through, seek instructions and get.
18th.
Please.
Ready note these matters, December 31. Ravi Kumar Gopalkar.
Appearing for the government, my lord.
Bill for petition.
Before that, your lordship said directed to include the Karnataka Lokaयुक्त as respondent number 6 and to submit a report whether there is any expenditure incurred or not. May I request for to 27/9/2021 order. May I read now?
Before that, may I apprise your lordship with some facts which are necessary? Why this court, this Lokayukta report has come into picture, that is some short facts are like this. In the city of Belgaum, there was a project for construction of STP, that is underground sewage treatment plant. It was supposed to be constructed at Alarwad village. The land of 50 acres was notified, which was partly owned by the private owners and partly by the state. The resolution was passed by the corporation of the city of Belgaum. Amount of 204 lakhs was already deposited with the water and sewage board. Thereafter, half the construction was done and the pipeline was also drawn. Everything was done. This was way back in the year 1985. And thereafter, all of a sudden, they stopped the work. Until 2010, nothing happened. Then for the first time in the year 2010, they notified some other land at Halga village. And thereafter, they started construction of the same treatment plant at Halga village. Inquiries made, representations were given by the farmers and as well the petitioners. Why you have left the earlier project, which was already half done, and 204 lakhs were already deposited by the corporation, which are collected from the residents of the city of Belgaum. You are accountable for that. And all this count, the petition came to be filed. In the prayer column, kindly see the acquisition which was sought in respect of these 2010 and 2011. That is 4-1 and 6-1 was sought to be challenged in the first instance. But I made a submission before the court that already the acquisition was in challenge before the competent competent writ court, wherein the acquisition is challenged and writ appeal thereafter is pending. Therefore, I not press so far as first prayer is concerned. Now the inquiry is confined to prayer number BC. That is ink page 11, if lordship pleases. A order direction in the nature of mandamus directing the respondent to start the half-done STP project at Alarwad, Taluka and District Belgavi. Then issue a writ order or direction in the nature of mandamus directing the third and fifth respondent to give the accounts of 204 lakh rupees spent for a half-done STP project at Alarwad, Taluka and District Belgavi to this honorable court. When the matter was pending, the fifth, this is third respondent, your lordship, kindly see, water board is third respondent. It filed a memo before this honorable court stating that it has received 228 lakhs from the corporation of the city of Belgaum towards execution of the work of this STP project at Alarvad. That memo stands on record. Thereafter, what has happened, Your Lordship? Again, when matters stood at this stage, the corporation commissioner, despite direction, did not appear. Therefore, a recent order was passed by the Honorable Court, whereupon an affidavit is submitted by the corporation of the city of Belgaum, that is on, this city is part of record, 22nd September 2021. So this is the root cause of the report from Lokayukt. Kindly have a glance, Lordship, please. 22nd September 2021, an affidavit filed by the fifth respondent corporation. In that page number 2, para number 5 of the affidavit. May I read it, Lordship, please? Para 5. I state that on 30th June 2017, the Karnataka Pollution Control Board, Belgavi, refused to give permission to setting up proposed STP plant. The reasons stated by the Karnataka Pollution Control Board for the refusal of permission are: A, the KHB has developed a layout adjacent to the proposed STP plant, and B, Belgavi-Bagalkot Road is approximately at a distance of 1.9 kilometers from the proposed site to the northern direction. It is stipulating 100 meters buffer zone around STP site, and availability of buffer zone is not possible at Alarwad site. They further opined that Halga site can be selected to establish STP plant, Halga of 75 MLD capacity for treating sewage generated from city corporation. Copy of the letter dated 30th June 2017 addressed by the Pollution Control Board is produced as Annexure R5. This statement exactly runs counter to what the report of the sewage board is, which is part of this writ petition. May I take Your Lordship to that? All this exercise was done way back in the year 85. Kindly, if Lordship pleases, the report of the water board itself clears this fact. Page 126, running page 126 of the writ petition, may kindly. Second paragraph, page number 126, if Lordship pleases. For treatment of 12 MGD on sewage of Belgaum city, the area of land required works out to 160 acres, 82 acres for first stage and 82 acres for second stage. The area locating near Alarwad was inspected and proposed for sewage treatment unit. The details of land required for treating the sewage have already furnished to the corporation authorities to initiate land acquisition proceeding. Then kindly turn to page 128. Location of wastewater stabilization ponds. Pond site has been selected near Alarwad village, away from habitation. This is very important. Away from habitation, and the same is located at a distance of more than 200 meters from residential colonies. The ponds are located in parallel according to the topography of the site condition. The site has been proposed to be leveled properly to locate the ponds in parallel. So this is what the report of the sewage board is, and the affidavit now.
Who is for pollution control?
Mahesh Chaudhary appears for Pollution Control Board and one Mr. Viresh Budiyal appears for respondent 3, that is the Karnataka Urban Water Supply and Drainage Board, my lord. And respondent 6 is the Lokayukta.
One more, if Lordship, please, interesting point here in para 5, I am referring to affidavit, patently false affidavit. Kindly see, this report objection is raised on 30th June 2017. Kindly see. This is what they say that Water Pollution Board
They're not part in pollution.
Pollution Control Board is not a party, my lord. Respondent 3 and respondent 5 are the answering respondents in the petition. Respondent 3 and respondent 5, my lord.
Day after, come day after. Nothing for that. It is, please, how can you in PIL challenge the acquisition? Come tomorrow, day after.
Case number 32. So Shailesh, yes.
So last order was passed. See the last order, 5/6 to 20. Report is in his favor. The 32.
31.
Where is your statement of objection? Something was produced last time.
6th April 2024. We filed statement on 6th April 2024. Not in which we filed Mahajar also latest spot inspection has been conducted. As per annexure 8. Photographs at annexure 7. Para 9, page number 6.
So any favor? Report is in favor.
No, no, his allegation is, my lord, dust is emitting from the crusher. When we conducted inspection in his presence, we found there is no such thing.
That is okay. So it can be allowed.
No, no, he is complaining against, my lord,
Against somebody.
against.
My lord, the issue which here is.
You
my
are
other friend was
complaining against
saying-
somebody.
My lord, my contention here is in this manner. my lord. The fifth respondent so far has not appeared before this honorable court, though notice has been directed. Initially, there was a report which has been filed. That report is also before this honorable court, the first inspection report as per the directions of this honorable court, in which there is a very clear categorical statement that the dust emanating from the stone crushing unit is falling on my agricultural land. It is also seeping whenever there is a rains come, it seeps into the ground. Subsequently, one more order came to be passed by which a second inspection was done. What has happened is even in that report, it is in my favor. But unfortunately, without any directions from this honorable court, the second respondent says, if your lordship sees paragraph 8, the respondent number 2 was not satisfied with the Mahazar drawn, that the points observed during the inspection were not stated in the Mahazar. So what he has done is in the third report, they come up with the statement saying that the dust is not falling on the agricultural crops grown by me. Irrespective of that, my lord, when they had given this, they have clearly flouted, when granting the license, they have clearly flouted condition number 6 prescribed, or section 6, which prescribes that the lordship sees. Pass on. This section 6 of the Karnataka Regulation of Stone Crushers Act of 2011. I'm only reading the relevant portion. License may be granted under this act, subject to the following conditions, so and so, so and so. Then come to G, my lord, 2G. 1 kilometer away from the limits of an inhabited village or any land recorded as forest in government records, or any private land which is shown as cultivable land in the revenue records. Now the inspection report says that I am growing tur dal in the land adjacent to the land owned by the fifth respondent. The stone crushing unit is located just adjacent to my premises. That is not permissible, is what I am submitting. And second submission is Lord, there is a memo which has been filed by the respondent along with the inspection report, which is on 31st of August 2021. At running page, along with the memo, the report is produced as per the direction of course, of this honorable court. There are some observations which have been made, which your lordship finds it at page 5.
When their report says otherwise, are we going to verify?
My lord?
What the report says we'll rely on, why?
No, what I'm submitting before this honorable court is 2 reports as directed by this honorable court shows that there is a dust which is emanating from the stone crushing unit. The respondent was not present. The industry was closed on all the days when inspection was done. On not a single day, the stone crushing unit was open or it was operational when they did the spot inspection. At least they could have ascertained whether the dust emanates and it is falling on my agriculture. Not a single day in all the 3 reports. The first report, only one sentence which says, deposit of stone powder in the agricultural land immediately located adjacent to the stone crusher boundary has been observed. Noise and ambient air monitoring was not carried out as the stone crusher was not in operation.
For orders Tuesday.
Please.
One submission I would like. Safer zone notification was issued in the year 2015 itself. Thereafter, for a period of 5 years, he has completed crushing activity. Now he has filed a renewal application.
Uh, 33.
I appear for the petitioners in 33.1, my lord. The matter relates, my lord, to the constitutional validity of the provisions of the Stamp Act, Karnataka Stamp Act, to the extent it impinges on the power of the central government to regulate mines and minerals. There are a batch of cases, my lord. Some of them are listed today. There is an order in another case to be listed also together with this. But I'm ready in this matter, my lord, to make my submissions.
May I kindly fix a date, Lord, because it requires hearing.
Oh, now in last week of July. 29th July.
My lord, I had amended the petition with your lordships kindly. The state has not filed any further statement of objections. So I suppose, my lord, they don't have any. If they have, let them not be permitted to file it before that date. They've already filed objections. Additional objections they have not filed after amendment.
If you want to file.
Yes.
Great.
Number 34.
Petitioners Council. Last occasion, your lordships heard for some time on the maintainability issue. The order of NGT had been questioned before my lords. Then I'd adjourned it, my lords.
What is it about? Appeal. Petition.
matter will have to be heard. My lords, your lordships did hear us on maintainability for some time and it was adjourned. But regarding, because I had questioned the order of the NGT before this honorable court in a writ. Lords, then your lordships had raised an issue regarding, instead of an appeal, how I could approach the court under 226. I had placed a judgment on the last occasion and even during notice was issued. Then it was stood over, my lords, to today. Lordship may have it next week, my lords. I'll argue on the main
Then
entire
after-
matter itself.
After 2 weeks.
Please.
For 35,
35 is the matter which you heard for some time regarding forfeiture of my entire security deposit on the tender issue, my lords, of 16 crores, my lords, because of the mistake in the.
Not today.
number 36, Nitin Ramesh.
My lord, 36, I appear for the petitioner, my lord. The state had undertaken to file a response, my lord. It's recorded in the last date of the order. No response has been filed yet by the state.
Lord, I haven't received complete instructions from the transport department, my lord. I pray for some time.
Learned additional government advocate, Snilo for there's further time to file.
No, it's a short date, my lords. 3 dates they have taken.
July. Time is granted, stand over to 24th July.
My lord,
24th July.
obliged.
Great.
Number 37, Gautam Dev C. Ullad. 37,
Appear for second.
4 weeks.
number 38, Murthy DL.
Appearing for respondent number 6, my lords. It's been informed to my colleague that they're seeking time, my lords. The appellants.
38, Murthy DL.
Where is your opponent?
My lords, my colleague was instructed that they would seek time today, my lords.
For the time.
A date may be fixed, my lords. We are ready in the matter. A date may be fixed, my lords, next week.
Date will be now in July. 22nd July.
Please, my lords.
Number 39,
Very for the appellant, my lord.
My lord, these all pertain to
30 days, my lord, 60 days delay in filing the appeal.
Lord, this have to be tagged on along with serial number 71, my lord.
See. Lord,
You know?
requires, my lord, the reconsideration at the hands of my lord, the learned single judge for this reason. The writ petition was, my lord, disposed of on 13/6/2023. My lord, the grant was died on 10/5/2020. My lord. The order of the learned single judge, my lord, passed against, my lord, a dead person. It's a nullity in the eye of law, my lord, which requires, my lord, lordship, so kindly remand this matter to the learned single judge and to give an opportunity for, my lord, the appellant.
This is a group. So, Yes.
Appellants are, my lord, the grantees of the children of the grantee. But the writ petition was disposed of, my lord, on 13/6/2023. Whereas the grantee, my lord, died on 10/5/2020.
But we'll take up together at the group, who are you?
This is, my lord,
My lord, this pertains to the very maintainability of the writ appeal.
You do one thing. Can it be in separate board? Separate. Make it separate board and we'll make a separate board and notify it on third. On that they will proceed with it. Keep separate. Third, all matters will be posted in a single board, on a single board, and then that board will take.
Number 40.
My lord, 40 also has to be called along with serial number 71, my lord.
Yes.
I have for appellant.
3rd July. Number 41. SB Mukanappa.
2 weeks time.
Along with 71.
Forty-two urgent. Number 43. Mr. Sachin BS.
Page 22 is the order of single judge. Single judge holds that it's a disputed question of law and fact, question of fact. Therefore, liberty was granted to me to approach the civil court. There's a bar which is contemplated in section 61 of Karnataka Land Revenue Act to challenge the grant order before the civil court.
So page 22,
It is page 22.
what is wrong in it?
My lords, the error committed by the learned single judge is that the grant order, that is allotment of house site, was called in question by the petitioner before the assistant commissioner. Assistant commissioner has rejected it. Same was confirmed by the deputy commissioner. Against that order, my lords, present writ petition was filed. Writ petition has been rejected on the ground that it's a disputed question of fact, therefore liberty is reserved to the civil court to challenge the order. There is a bar contemplated in section 61 of Karnataka Land Revenue Act. If any order passed in exercise of the Karnataka Land Revenue Act, the said orders cannot be challenged before the civil court. Therefore, my lords, the learned single judge erred in rejecting my writ petition by granting me liberty to approach the civil court. I have challenged the grant order which was granted in favor of my opponent. That is, allotment of house site was under challenge. The grounds urged by me for challenge for an allotment of house site is that, my lords,
for the purpose of allotment of house site, there should be there be a constructions. My lords, here in case, after allotment, my opponent proceed to construct the house. A spot inspection was held by the Tashildar. On spot inspection, it was held that my opponent has put up the commercial building. And the grant order itself is in violation of law. I draw my lord's attention to the very commissioner report, very inspection report itself. So there is no disputed question of fact. The fact is already on record. Learner single judge has not taken note of the inspection report. I draw my lord's attention to page number 90, which is a part of record in the writ papers. Page number 90. Kindly see page number 90. This is an inspection report which was produced. Page number 90. I'm sorry, my lords. Page 90. That is annexure L. This is translated copy of inspection report. Point number 4. Point number 3. According to report of the village accountant, as per their office document number so and so, there is no residential building in the site allotted. Instead, there is a commercial building. It is in the region of Hole Paramboku. Point number 4. In appeal filed by the Court of Assistant Commissioner Sujata Thomas, being the first respondent in this case, has given false information and report to the Court of Assistant Commissioner that the grant of house plot under so and so section rule so and so may be considered as case for cancellation of a sanction submitted. So therefore, my lords, the report submitted by revenue inspector, which shows that, my lord, very allotment itself is bad. This was a part of record in the writ petition papers. My lords, the very grant order allotment was challenged by me, saying that such a allotment itself is bad. I filed an objection before making allotment. My objection was not taken note. In spite of filing objection, my lords, allotment was made. Then I have challenged the allotment before the AC and DC. Both the AC and DC has confirmed the order of allotment. Now, learner single judge says that you get your remedy redress before the civil court. Kindly take a note of section 61 of Karnataka Land Revenue Act. There is a complete bar provided, my lords, where we cannot approach the civil court challenging the grant order. All that I am requesting, my lords, is that let the learner single judge reconsider the whole thing. Let my contention be considered. My lords, the learner single judge has not taken note any of the contention which has been addressed by the petitioner. My lords, if my lords have a look at my writ petition pleadings, I have pleaded everything. Make a note of at page number 32. My lords, in addition to this, I also made an endeavor to secure the revenue entries which are standing, my lords. Even today, the particular survey number stands in the name of the government, page number 68. So therefore, my lords, my respectful submission before my lords is that the learner single judge has erred in rejecting my writ petition and granting me a liberty to approach the civil court. It is only under Article 226, my lords, my grievance has to be redressed. Civil court has no jurisdiction to redress my grievance. Is my respectful submission.
All right, appeal admitted to be listed for final hearing in the week beginning from 4th November.
My delay be delay application.
Delay application is
20 days.
How many?
20 days.
And write down in delay, or delay is gone down. IA number 1 of 24, delay of 20 days is paid to be gone down. Delay is occurred due to Delay is sufficiently explained. Delay is adequate, delay is properly explained. Sufficient cause is made out. Delay is found on, application is allowed. Then writ appeal ma.
4th of November. 4th November. Obliged.
Grateful. For orders, number 44. We'll use party in person.
Here for the accused in this matter. On 12 June 2024, we have complied with the order, Your Lordship.
The Tahsil has complied with the order by issuing a EWS certificate on 10/6/24. Your Lord.
Petitioner so and so states that the Tahsildar has complied with the order. The compliance is confirmed by learned additional government advocate Mr. Jaffer. In view of above, nothing further survive in the present proceedings. Contempt petition is closed, not issued discharge.
Your Lordship, there's another matter. I had given a letter to your office on 11/6/24 through Registrar Judicial. A private letter was, sealed cover was given to your office, Your Lordship.
Will inquire. Give the details.
Symbol 45.
Here for the-
Chandrasekhar PA.
Therefore, the complaint, Your Lordship. There was a direction issued by this honorable court for furnishing the details of the salaries paid or the payment made to the complainant. Till now, the accused have not furnished any details. The complainant has not received his salary from period of 27 years, Your Lordship. He's been working in the institution from 1997 till now. And now they have come up with another, they have sent another letter saying that the post it will be terminated and he'll be terminated from the post.
Lord, what has happened is that, my Lord, there was a finding by the learned single judge stating that he is not the regular employee of the institution. He is only a part-time lecturer in the college. And there was a direction to consider his representation. And as far as the representation is concerned, my Lord, we have heard the complainant and passed the appropriate order. And the copy of the same is produced, my Lord, by the learned friend at annexure M at page number 125.
Your Lordship, the direction was to consider the representation regarding the salary to be paid, Your Lordship. We are asking the salary, he has been working for the period of 27 years. So what the salary is being, is supposed to be paid, we are asking the same salary, Your Lordship. We are not alleging any different, as my learned friend said.
Lord,
He has not been
claimed a
paid.
salary at the rate.
At page number 72, Your Lordship.
57 lakhs he claims. How he has come to that figure, he should give at least a breakup. Now what the finding given by the learned single judge and as well as the division bench of this court is that he is only a part-time lecturer. And part-time lecturers' salary were being paid. Now he claims that I am due for 57 lakhs, 7,700.
As my learned friend said that the salary is
filed
being
objection
paid,
statement.
but they have not paid any of the salary, Your Lordship. In page number 72, Your Lordship, in the writ petition of the statement of objection where they are filed, they said in page number 74, as per the in the middle of the paragraph, as per the contract between the part-time lecturer and the management, the salary is being paid. They're saying the salary is being paid, but till now they are not shown any of the proof that the salary is being paid. The complainant has been working from the period from 1997, Your Lordship. And as per all the contentions which were put before this honorable court, so the honorable court had directed to furnish the details of the salary which is being paid. So they are not furnished the details of the salary which is being paid already. They're saying that they are paid, but the complainant has not received even a single penny, Your Lordship. And there is an affidavit which has been filed, where it's been affidavit filed by the PU board director, your lordship. They said they have added an annexure, they have produced an annexures, which is in the translated copy. In page number 9, your lordship, last paragraph, as such furtherance, page number 9 of the affidavit, your lordship. Last paragraph. May I read, your lordship? In the affidavit filed by the deputy director of PU board education, in this case, they have filed an affidavit. PU board secretary. 20th September. Page number 9, your lordship. As such, in furtherance,
Put up on Monday.
Detail number 69, my lord. And for respondent, I filed application for vacating stay. The appellant obtained the interim order of stay. Till today, not complied the office objection. Application for stay may be continued.
Number 55, it is contempt as a writ appeal. I filed contempt, thereafter they filed writ appeal.
Even
My lord, serial number 45 may be directed to be posted next week, my lord. 46, my lord, 46.
Lords, 15(9), my lords, I filed an application for impleading. My lords, formally that application may be allowed, my lord. This matter may be taken up on Monday, my lord.
74, is for the framing of charges. I am complaining. Kindly give charge date. Tuesday or Wednesday.
It will not come here, it will come here. Criminal contempt. Criminal contempt. Will-